examine my IA also. I'll make a listing memo. And your lordship may examine and if possible, because on 15th of June, otherwise my shares will go and it will become an irreversible situation for me.
My lords, may I mention civil appeal? My lords, this is the civil appeal filed against the order of Honorable NCLAT, wherein they've dismissed our appeal and CIRP has been initiated. Is there apprehension that the
CIRP has been approved by NCLT, your
My
appeal
lord.
has been dismissed by NCLAT,
My lords,
and you want us what?
my lords, I've just e-filed my civil appeal yesterday. My lords, may kindly allow it to be listed on 27th.
We will see it if free from the defects, then we will.
Please.
That's on
My lord.
Friday.
But may I mention a matter for NDPS bail matter? Lord, the matter was listed last on 8th April 2026. Lord, unfortunately, the judge has retired, Justice Bindal has, but the matter has been posted on 22nd of July. I don't know why. Lord, he has already spent 3 years. If your lordship keeps it in this side,
In court number 1 here.
Sorry?
Is it court number 1 or some other court?
no, Lord, the bench that had heard it was Justice Bindal and Justice Manmohan. Justice Bindal has retired, but the matter is posted on 22nd July, my lord.
So,
Any date this side of the vacation. It's bail matter.
are you available in any of the weeks in June first week or second week?
Sorry?
June 1st week.
My lord, June 1st week.
We'll try to list this week, but otherwise first
Much
week of June.
obliged, yeah.
Lordship, this is a fresh matter,
One matter,
which is
Friday, your
Article 32 matter, my lord, one MLA, his life and liberty is in danger. My lord, I have filed an 32 application, may be listed, my lord, tomorrow.
Well, it's on Friday.
We'll verify.
Fresh
Lordship, my commercial suit has
matter has been filed, my lord.
My lord, I am mentioning a matter, very
Follow
urgent matter.
give your these mentioning memos where you must have mentioned some reason. We will verify unnecessarily.
My lord,
You are also
very urgent
wasting your
because
time.
same RL has issued a attachment cum possession letter. So they are trying to take forcible possession. That's a very urgent
And
matter.
therefore, I should accept it light. We'll again get it examined. Please hand over to registrar.
Well, it's on Friday, my lords, it passed an order. I'm only seeking modification of
Another
3 words in
my
that
lord,
order. Your lordship,
Date is shown,
your
date
lordship,
is shown on 29th May. I am only requesting not to delete on that day.
We will see.
my lords, on Friday, my lords, it passed an order giving me liberty to approach the High Court. I'm just seeking, my lords, 3 words, my lords, my lords, perhaps inadvertently, the order says that the directions of the NGT had been issued in a petition filed by the petitioner. I'm requesting that the words had been issued be replaced with were relied upon by the petitioner. That's it.
Whatever is.
Yes, my lords.
Lordship, my commercial suit has been pending in the Bombay High Court, consistently adjourned. So I have filed a fresh SLP against the last order of 27th April, in which the judge had recused because my matter is not getting reassigned now. So,
Go and tell the Chief Justice of the High Court, if you are learned.
Lordship, we have already filed 2 urgent precipices there.
It has become.
My lord, it is not
You want
for
us
this.
to run now every High Court affair.
My lord, it is
Listen
not,
before Chief Justice of the High Court, please.
My lords, I had passed.
The Lordship will take care of.
My
my lord, it is not for listing. Yesterday was the last day for filing written submission in Shabarimala matter. I may be permitted to file today, otherwise the registry won't accept it. Yesterday was the last day for filing the written submission in Shabarimala matter, my lords.
All right, you can do today also.
Well, it's the order that we just passed upon, my lords. My lords, para 3 at the top of page 2, my lords. The directions. Well, it's the directions of the National Green Tribunal
The National Green Tribunal had been issued in
had been issued,
filed a petition.
were relied upon in a petition, my lords, instead of had been issued. Mine was a subsequent petition relying upon the earlier direction of it.
On the oral mentioning the matter is taken on board, the order dated, para 3 of the order dated 22nd May 2026, in order to be.
My lord, I want to draw.
To the following extent.
Your lordship,
Please allow us to correct one more small order. The last line of the para 3 of the order is ordered to be corrected, which shall now be read as follows. Then say the directions of the National Green, the petitioner, as a the petitioner relied upon the directions said to have been issued by the National Green Tribunal.
Please, ma'am. Grateful. Deeply.
your lordship, I filed an application. I'm requesting for urging of the same. It is with respect to salaries and benefits of certain of the applicants. It may be listed this week or after the vacation, your lordship.
We will see.
The day,
Please send your memo explaining
Yes.
the reasons of urgency. We will see what is good.
Lord, that's my colleague. May I just explain this matter? It relates to Mahesh Chandra Sharma case, and I am receiving 50% of the salaries. I'm representing government doctors. And I'm requesting this matter may be listed in July first week.
July.
My lord, may I draw?
During partial working days.
I'm so sorry, the
On
first
opening.
week, on opening, yes, yes.
On opening, no problem. Anyone asking to list the matter in August, September? All right, then your request is.
My lord, may I draw a kind attention towards the matter, the cockroach issue. Even after the clarification of the Honorable Chief Justice of India, my lord, a distorted and malicious narrative is being continued.
Don't take it so sentimentally.
Seniors of this honorable court had joined the hordes with them, my lord.
Learn this lesson also.
Attempt to demolish the image of the institution, my lord.
My lords, I'm mentioning the same writ petition civil. In regard to it, we are praying that the oral exchange of the courtroom proceedings.
Just repeat again. Just repeat again.
My lords, I am mentioning a writ petition civil wherein we are praying that the oral exchange in the courtroom proceedings cannot be utilized for the commercial purposes. Other than that, we are also praying for the CBI probe in regard to the statement given by learned chairperson of the BCI that there is 35 to 40% fake degrees in the law.
We will see. Don't worry.
Your Lordship.
There is no such grave urgency in these matters. We will consider in due course of time.
Your Lordship, may kindly allow me to mention a transfer petition. The matter is listed before the trial court on 4th June, and the service is completed in the matter. We request that it kindly be listed before the ensuing summer vacation.
No. Before the trial court, it is listed on 4th June.
Yes, Your Lordship.
What is the matter coming before us here?
Your Lordship, it is a transfer petition. And for the petitioner wife and with a minor child.
Service is complete in this matter. In this transfer petition, service is complete, my lord.
We will see. All right, thank you very much. Now start us some work also.
Wait, please, Your Lordship. I appear for the state of Madhya Pradesh.
Mr. Solicitor General, you see 2-3 aspects which were there. One was with respect to the second autopsy that has been done. The High Court has done a commendable job. They passed an order. And as we could read, my brothers also read in the paper that now cremation has taken place.
Yes.
So that aspect is over. Now the other thing is that, and we appreciate the state's prompt action, they recommended for CBI investigation.
Yes.
Anyone representing or Mr. Solicitor, ask the CBI to take over the investigation.
My lord, I'll talk to my lord that.
Why we are saying we are slightly at pain because some of these sections, and we will request our media friends also, please, that we will definitely request them that don't go for the statements of the victim's family or the other family, and let the things move in the as per the law and procedure. The authorities, the investigating agency, they will follow, because otherwise statements are being recorded. And one section has started saying, because I think the mother-in-law happens to be a former district judge.
Yes.
Yes. Some of the it's quite unfortunate that they started saying that judiciary is not permitting to have a fair trial.
I am appearing for the
Anyway,
accused. I am appearing for the accused. My entire 161 statement is in the papers today.
Mr. Dave, we don't want to cause aspersion against anyone.
Yes, my lords.
We have no reason to doubt that the victim side also will fully cooperate. The other side will also fully cooperate. And we have no doubt on our state agencies also or on the CBI also.
Lordship, please.
That whosoever will investigate, they will definitely take the investigation to a logical conclusion.
And impartial.
They will reach out what is the truth. We are only because this kind of a narrative is being created.
Yes, I'm obliged to.
Therefore, it is in the interest of all.
Yes, my lord.
That we should expect that some independent agency should take over.
Lord, that would be done. May I only say one thing, my lord, why this has started? Lord, one of the potential accused, my lord, the learned former judge, my lord, has started giving interviews, hopping one channel to another, and, my lord, almost maligning the deceased. Therefore, my lord, there is a reaction and counter reaction.
No, there will be no.
Never have happened. Only a minute, Mr. David.
No, there will be no. I'm assuring you, there will be nothing on instructions.
I appear for the victim's family, will have something to say.
We are not
Second thing,
interested in a
with which
media.
the investigation is concerned. Lord, the FIR was registered, my lord, on 15th May. The concerned, my lord, potential accused, the mother-in-law, my lord, described her as mother-in-law, moves an anticipatory bail, my lord, on 14th of May. hearing concludes and granted anticipatory bail on 15th of May. Lord, which is under challenge by Lord, the victim as well as by the state government also. The difficulty is, Lord, despite our repeated request for her to come and get her statement recorded, Lord, there is no cooperation.
Well, it
Lord,
can't be
last-
said here.
Only a minute, Mr.
Oh, no, this is not fair.
Lord,
my lord.
this-
It can't be said here.
Last,
This-
Lord, we intimated her that we would come there and get your statement recorded. She said, no, I'll not get my statement recorded. We could, my lord, with difficulty, Lord, collect, my lord, or seize the mobile devices, etc. Lord, that's investigation is going on, my lord. I would not like to prejudice either of the sides. But there is, my lord, a non-cooperation.
We have absolutely no doubt on the state police that they must be doing and they will continue to do it with complete fairness and impartial. And normally they do it in a very dispassionate manner. Barring a few instances might have in the past as well, but the correctional measures have always been taken wherever this kind of things have happened. In this case also, we do not want to demoralize the state police. They must be doing a very good job.
But in any case, now it's gone to CBI. my
Because
lord.
the state government has requested.
Yes, my lord,
They have requested.
so that there is no
Yes.
fingers, my lord, pointed out.
Section is very fair, completely above board, because the moment a narrative was created, they said, oh, like you, please don't doubt us. We have, our bona fides are very clear. We want to send.
And the mother-in-law statement was recorded, in fact. More than thrice it was recorded, the mother-in-law. All that can't be argued here, my lords, as far as the investigation to the prejudice.
Because once the state has recommended, in fact, we don't want to even issue a direction for that. There is no need to.
No, my lord, CBI would take over, my lord, but now state has.
And they should for it immediately.
I'll speak to the director, my lord.
That will be appropriate, not because of the solicitor intervenes, not, otherwise today, my lord, DOPT has to issue a notification under 6, not, that's not happened. So even though the state has done it, still the DOPT response will remain in limbo.
It's not as if the state has not done anything.
It gives consent and hands over the investigation. It's an administrative exercise between the state and the center.
That will
or
be done.
rather the CBI under the DSP Act. So there is no question of judicial intervention here.
No, not judicial. What my learned friend perhaps says is that there is a ministry called Departmental of Personnel and Training, which is the, my lord, the nodal ministry for CBI. So they issue a notification based upon the consent of state government.
Correct.
That's a formality. The lordships are right.
Yes, the state has,
To do it under
once the state has consented and recommended. I think
I'll ensure that that happens today, my lord. I'll speak to the concern.
with the intervention of your good officer, it will be expedited.
It shall be done.
I think there is no other issue
There are a
surviving.
couple of issues, Lord. Just kindly just take my note. Lord. I've tendered a note to your lordship. There are certain concerns which we have right now, which your lordship may consider, Lord. But kindly just come to the second page for a moment. Lord, the issue which your lordship will have to see, because this is an issue of institutional bias, so please see it. Kindly note, Lord, there is a 3-day delay in the FIR registration. There is a failure, according to us, to preserve the evidence because it was all
So,
open.
Luthra, all these issues, once the CBI takes over, then these are all matter of
Lord,
investigation.
till the CBI takes over, these will have to be addressed, Lord, because each day, Lord, the evidence is likely to get lost. Kindly just see it for a moment. Number same, Lord, the mother of the...
No, Luthra, we should be very clear.
Lord,
We will not-
suggest this.
But this is
May I
investigation.
suggest this,
We will not, we will ensure that that victim or whatever the unfortunate incident has taken place, it must be fairly and independently, impartially investigated. That's all. There were doubts. You were also going unnecessarily to media. The other side is also going to media.
Yes.
This is our request to you. Whatever statement you want to depose, you please make before prescribed authority, that is the investigating agency. That your statement recorded. Our request to, we will, of course, we can't do anything, but we can only request media also, please don't go for recording statements of the victim's family or reducing their pain into sound bites, please. That's not the way anybody should do it.
Very grateful.
Because this very unfortunate incident has taken place. Both sides are might be.
It's not a subject matter which can be sensationalized. At the same time, it's because of, my lord, this media intervention that several things have taken place.
No, undoubtedly, they help a lot.
Whole also, my lord, is
Our only concern is not to statements, because
yes.
what the statement they will make, where they will make, that creates problem.
Even the statement in the police custody is
It's
reported.
only because of they highlighting that, after all, it came to our notice also only because of them.
Lord, in fact, our
Yes,
concern is,
yes.
Lord, our concern is not the CCTVs in the open domain. There are the lady, the mother-in-law produces her own CDRs which have been flashed around. Not these are not things which.
Yes, this is what precisely we are requesting both sides. We are requesting all of you, please do not make premature statements like this. In any case, there is a law prescribed mechanism of making statements, recording statements, follow that procedure.
Absolutely.
And there is already, the state police was already investigating.
Yes.
You can go, whatever statement you want to get recorded, please go there. Now that maybe that during the course of day CBI takes over, you get your statement recorded there.
Just make one request, but I don't want to read it specifically. Not just read point number D at, give him a copy.
I have a copy.
Point number D at page number 3, Lord. I just want your lordship to see that for a moment. I don't want to read it. We are not here to sensationalize matters.
No, please don't. And we hope you note it's not circulated here.
Even we are hoping that. I don't want it. I don't want it. These are all his
I'm just,
answers and I will
just
turn it
pointing
to
out.
him.
That's all I give him.
Mr. Luthra can
This,
keep. You can give it to the learned
These are-
This
solicitor.
is, my lord, in public domain, my lord.
Not
He-
this is not this
he
is an
is
issue in
something,
the
my lord.
public domain. This is something in the domain.
This is all in investigation.
I've limited my request only to Lord B, para B.
No, we will not take notice of anything, Mr. Luthra.
Obliged. I'm
That is
obliged.
very unfortunate that you want us to take all the.
But I
Is
want
it
your
done
lordship.
by the investigating agency?
What I'm saying to your lordship is let them do this part. That's all. I'm not asking.
They will do it.
We appreciate your concern, that you had a very serious concern that you somehow or the other thought, and maybe some instances here and there that you thought that you are not getting a fair trial investigation. That has been ensured now. State immediately promptly acted. They gave consent, they recommended. Now, it's only a procedural part, and with the.
May I just say this?
I have a lot of things to say in my defense also. I can produce all that this is not an offense.
A representation not based on this to the state. Let them look into all
Luthra,
these.
do you, with your experience, do you recommend this kind of representation in this matter?
I'll tell your lordship why. I'll tell your lordship why I'm seeking this, but because there are certain materials which have not.
Unless you want something to be, of course, if you want certain things to be published, even.
I like.
No, Lord.
Yes.
It's a different issue.
Yes.
I'm saying, Lord, there are certain aspects which we believe, Lord, which are not being taken note of or covered. So we'll inform we'll give them a point of view. They can act on that. It's not to be put in the
No,
public
only
domain.
one, my lord, moral of the story, forgetting this for a while and without attributing motives to either of them. One thing is clear that the girl has lost her life, whether it's by suicide or by any other criminal act. My lord, it's always better for all parents.
Undoubtedly, she has died an unnatural death.
That, my lord.
What was the cause and all these things?
Lord, for parents, the moral is that it's better to have a divorced daughter than a dead one.
Absolutely.
When she is repeatedly saying that I am living in a hell, please save me,
The
please
kind
save
of
me.
pain and agony for parents,
Yes.
for close, near and dears, for family, and even for society also sometimes. It's something unbearable. There is no doubt about it. We all have sympathy with them. But then the law, there is a procedure followed.
Certainly, my lord. No, I am not on the
Solicitor, the seriousness of the incident and the offense cannot be undermined.
Very true.
Generally, my lord.
Natural death within 6 months.
Within a few months.
Within 6 months. What you are saying is a dragging of the matrimony in view of conventional feelings that marriage
That's
should
exactly
continue.
what I'm grateful.
Would have been understood if it dragged on for 2 years. But when it is within 6 months, even the reaction time will be something more than 6 months.
Correct. I'm saying in general for the parents that better to take that call immediately rather than losing the daughter.
I think, Lord, it was just
Anyway, my lord,
really shocking and unexpected.
So Ms. Trisha Soma, a 33-year-old person, former actor, unfortunately died an unnatural death at her matrimonial home in Bhopal on 12th May 2026. A news article published by India Today on 18th May 2026, followed by several media reports, were thereafter published alleging institutional bias and questioning the fairness and impartiality of the investigation which was being conducted by the state police. The reason as it was perceived for, the reason that was reported for the alleged lack of impartiality was that the husband of the deceased is a practicing lawyer and her mother-in-law is a retired district judge. That's further. It thus appears that the family members of the deceased questioned the response of the police authorities and alleged undue influence in the matter of investigation. A narrative was also created as if fair investigation was being denied on account of involvement of the judiciary. It is in this backdrop that these suo motu proceedings have been initiated by us. That's further. Meanwhile, certain developments have taken place. The Madhya Pradesh High Court filed an order dated 22nd May 2026. Took notice of it concern, one of the concern of the family members of the deceased and directed that a second post-mortem examination was necessary to clear all doubts from any quarter and also to bolster the confidence of every common person in the entire process. We are informed that in reference to those directions, Sri Tushar Mehta, Learned Solicitor of India, representing the state of Madhya Pradesh, informs that in reference to those directions, the second autopsy was conducted by the All India Institute of Medical Sciences.
Lord, it was conducted at Bhopal. The team flew from Delhi.
Was conducted
by
a team of doctors from the All India Institute of Medical Sciences,
Delhi.
New Delhi. So the second post-mortem was conducted at Bhopal.
But other than bringing the body here,
That's
that the doctors go.
That was the appropriate reports. Thereafter, the body has been cremated yesterday.
Yes.
And that report is awaited, my lord. The second report is awaited.
That's further. The only issue as of now arrives for consideration is the consent and recommendations made by the state of Madhya Pradesh seeking to hand over the investigation to Central Bureau of Investigation. Since the state government has already recommended investigation by CBI, our Learned Solicitor General has assured us that he will take up the matter with the authorities so as to ensure that the CBI immediately takes over the investigation and make an endeavor to complete the same promptly. we would like to impress upon the family members of the victim as well as the accused side that instead of making statements in public or before media platforms, they should get the person recorded before the investigating agency. So that no prejudice or adverse impact is caused on the ongoing investigation. As observed earlier, orally, we also request the media to avoid recording statements of the persons who are likely to be potential witnesses
Or accused.
as it may not unnecessarily give premature impressions and or as it may not unnecessarily prejudge the outcomes which are yet to outcome on certain issues which are yet to be investigated. We will also request the general public that they should refrain from speculation and or to have trust and faith in the one of the premier investigating agency who, we are sure that in due course of time will take the investigation to a local conclusion. That's all. While making observations here and above, it is clarified that we have not expressed any opinion on merits of the allegations or otherwise, and it is entirely to the investigating agency to look into the different aspects, scope versus pros versus of the parties. Anything else at this?
That the high courts, etc., my lords, may be free to proceed. Since it's a suo moto, your lordships have constituted. High court, etc., can proceed in the manner if there is any petitions, etc., before the high court, my lords. In the manner, those courts. This may not come as if the other courts are denuded of that power, my lords, of the lower court or the high courts in the state of Madhya Pradesh.
But I have one thing.
Since your lordships are keeping it pending, since your lordships are keeping this pending, so it may not be that if we have to approach and exhaust our legal remedies by other courts, it's available to us, my lords.
For us to keep it pending. For us to keep it pending.
Then it's fine, my lord. Then it's not being paid.
But just one request, Lord. But I am not making that request today, but at some stage, Lord, if I leave the issue of my right to seek transfer open, Lord, because it should not be that we came here, we didn't make the prayer at the first stage. I'm not making it today, but I want that issue left open.
Transfer of what? Investigation.
We have not expressed any opinion with respect to the
Rights of the party.
the rights or privileges of both sides.
Yes.
Which they might, for which they will be entitled to
Take a vote.
seek, which they will entitled to seek before an appropriate forum in accordance with law.
One suggestion subject to your lordship's approval. The lordships have said that those people who are likely to be potential witnesses may not give any media statements. If your lordships can add potential accused also.
Potential witnesses and accused.
Potential accused.
Yes. Even they are also in a way defense witness.
Yes,
Because
but they might be accused themselves. So that's the.
Because tomorrow, whatever they unnecessarily will say, that might be their defense. So they should not unnecessarily go to media and make statements.
We're grateful, my lords, to your lord.
Grateful to your lord.
We are obliged.
Lord, the learned advocate general is also not online.
Yes, Mr. Prashant Singh, we have.
He has heard not everything. He was.
And I am also assisting learned solicitor general.
Obliged to.
We are deeply obliged. Deeply obliged.
Thank you.
I appear for the Union of India in the matter. We have been served with the 500-page counter on Friday itself in 2.3. We may be granted 2 weeks for a joinder, and it may be listed in the partial working days if my lordship deems fit.
All right, your directions are complied with. Land Council for Union of India stated that counter affidavit was received on Friday only. So 6 and granted. 4 weeks time to file?
4 weeks time.
What's the matter on something?
Grateful.
Please, my lords. My lords, here, my lords, we're pleased to issue notice. There is a response that has already been filed. My lords, this is a case where all the other accused, both in the EOW matter as well as in the ED matter, have been granted bail. For example, in EOW matter, my lords, there are in total 25 accused who were arrested and 24 have been granted bail. I'm the only one who...
Just a minute, madam.
I'm sorry, ma'am. Yeah.
Item 9.
I beg your pardon, madam? Item 9. I'm sorry, my lords, I hadn't switched over. My apology.
Lord,
I didn't realize that.
So I appear in 9,
Yes.
the state.
My lords, I have a short note that I have drawn up, giving the details of both these matters, just to summarize it for my lords, the status. Would my lords just take this?
You have
Give
already
them also
granted
copy.
bail to some of the.
I beg your pardon?
Some of the persons we have already granted bail.
My lords, everyone has been granted bail. My lords, may I just sum it up? In EOW matter, there are in all total 25 arrested accused.
No.
Out of 25, 24 have been granted. I'm the last one.
First item is that liquor.
EOW one.
EOW.
EOW. The state.
The predicate offense.
That's the predicate offense, my lords, arising out of the FIR. Yeah.
No, this, we are just referring to the Niranjan Das 6457.
Please, my lord, 6457 is the EOW. It arises in the predicate matter in which I'm seeking a bail. Yes, my lord. And my lords, in this?
This is the state FIR.
This is the state FIR.
As we call it popularly, that Chhattisgarh liquor scam.
Yes, my lords, it's called the Chhattisgarh liquor scam.
So we have granted bail to our.
My lords can see my lord's order at page number 221, annexure P18, in the case of Tawasi Lakshman.
It's not a threat tampering. There's no that. Yes, there's no threat of him tampering. At least he's one of the most well-behaved.
My lords, I am a retired officer today.
Insofar as he is concerned, he was the main accused, main official.
They've said it for everyone.
All right, all are.
No, my lord, I'm not.
It was
what I'm
said
saying
for all
is-
the accused, the same
My lord,
treatment.
He was the excise commissioner under whom this policy was tweaked, my lord. And then he gave the order to a company for holograms, my lord. And they're fake holograms, and which they used to circulate fake liquor. Now, my lord, may kindly see, insofar as he is concerned, he was arrested in December by ED.
No, it is not your matter, it's the state matter.
The next matter is mine, my lord.
Well, next we are arguing in advance.
Because
let us.
So, he was only arrested in September, but investigation.
Right, on the petition.
His role was omnipresent. He was secretary. He was secretary excise. He was commissioner excise, and he was also the chairman of the marketing corporation. But
That is Arun Pati.
that's Arun Pati.
Yeah, that perhaps is not correct. I don't think my learned friends are aware. The chairman of the marketing corporation was Arun Pati Tripathi. My lords have already granted it. I
The
beg your-
petition seeks enlargement on bail in FIR number 04/2024. By the Economic Offence Wing of the Anti-Corruption Bureau State of Chhattisgarh. Lodged by the Economic Offence Wing of the State Police at ACB Police Station, Raipur, under Section 424, 67, 468, 471, 123 IPC and Section 7 and 12 of the Prevention of Corruption Act. The petition was the Secretary, Excise Department, and it appears that subsequently he was appointed as Excise Commissioner after retirement.
Minister,
He was appointed after retirement
he was
as
serving. He was serving. He has
as
two
excise.
roles. Secretary Excise, Commissioner
He is
Excise,
said to have
and
commanded
Managing
oversight
Director of Chhattisgarh
over the entire
Beverage Marketing
process
Corporation.
and was complicit in formulation of beneficial policy for perpetrating the alleged crime. Next, the petitioner was arrested on 18th September 2025. What is the investigation position?
Minister, investigation, we are filing the final charge sheet. Minister, there's some last leg. We'll file the charge sheet within next 30 days. Minister.
We are informed that investigation is near conclusion and
For him, it's complete. For him, the predicate offense.
we are informed by landscape, by additional Advocate General that investigation for the petitioner is complete.
Yes.
And charge sheet is likely to be filed.
My lords, for him it is filed.
For him, is
For him it is filed. They have filed in fact two charges thereafter too. Yes.
Also, the investigation in respect of to some other co-accused, some co-accused is still going on and is likely to be concluded. So, the trial, however, is yet to formally commence and its conclusion will take some time. The co-accused of the petitioner have already been released on bail by this court or by the High Court. The various orders, including order dated so and so, passed by this court in so and so. It's taken into consideration all the attending circumstances, or without expressing any opinion on merits from an instant petition is allowed, and the petition directed to be released on bail, subject to furnishing bail bonds, with satisfaction of so and so, impose the same condition as on the others. Now, what is the next case?
My lords, the next is the ED matter.
EMLA matter.
I have given a note so far as that also is concerned, my lords. All the investigation is over. I was in the 5th prosecution complaint. They have subsequently filed yet another prosecution complaint. So investigation is still not complete. Yeah. Yes. My lords, they have filed a counter affidavit and page number 533. My lords will find this specific thing that they have said further investigation is pending in the ED case. Now, my lords, there are total of 6 prosecution complaints filed. I was taken in on the 5th prosecution complaint. They filed yet one, and according to them, it is still not over. Now, my lords, there were total 9 arrested accused so far. Out of the 9, 8 have already been granted bail. I'm the only one who's pending.
8 have been granted bail in PMLA also.
In the PMLA. I'm arguing just now the PMLA matter, my lords. And my lords, all the excise officers who were there, I was, according to them, the commissioner, but all the excise officers were granted bail without even arrests. Without even arrests, and they were granted anticipatory bails by this court. Now, my lords, even in this matter, there is no likelihood of any completion here because there are 81 accused, there are 117 witnesses, and there are 200 section 50 statements. So, my lords, and there are already 6 prosecution complaints, and yet they have not given the final complaint. So, there's no likelihood of this coming to a conclusion at any near distant future in this particular matter. There's not even charges which have proceeded here. And my lords, scheduled offense, as my lords have already seen, there are 1,200 witnesses in that scheduled offense and 55 accused. Now, ED can never conclude before the predicate offense is concluded in that. Now, my lords, I am respectfully praying they have filed a complaint against me. They don't need me at all.
But we have filed the PC in respect of this accused.
So your investigation is complete.
Not in respect of the whole offense.
So your
not
statutory complaint, how many years it will take?
Actually, the big syndicate which was operating.
Really press hard for early because it might unnecessarily lead to, ignoring the vital evidence.
The POC proceed of crime. I mean, so far as him is concerned, it's already over and we have filed the PC. But he was the main person under whose aegis the syndicate was functioning. And in fact, he used to give directions to the concerned officers not to.
That's why he will be the last one to go out.
He was the last to be arrested also.
My lords, he was always there. It was for them when they chose.
To be arrested.
I cannot have a role in that, my lords. It's not their case that I wasn't available.
So the petitioner seeks enlargement on bail in a case registered by Directorate of Enforcement to ECIR stroke RPZ stroke 04 stroke 2024 under sections. What is the provision at 3(4) in section
3(4) of the PML.
3 and 4 of the PML. Pura Vikran Act. The predicate offence is FIR number 04 stroke 2024 dated 17th January 2024. वो जो पहले वाला बेल का अपराध है, registered by the Anti-Corruption Bureau of the State Police by the Chhattisgarh State Police for offences and so and so, so and so. The petitioner was the Secretary Excise Department and subsequently he was posted as Excise Commissioner. He is led to have commanded oversight over the entire process and was complicit in formulation of beneficial policy for perpetrating the alleged crime. The role assigned to the petition is thus of the orchestrator and he is described as one of the kingpins. It is also alleged that the petitioner grossly abused the public office, causing large-scale financial implications to the state, etc. Next paragraph. The petitioner has been released on bail on the predicated offence by an order of even date passed separately. In the PMLA to the 19th December 2025, there are 9 accused, instead of 8 have already been released on bail in PMLA case also. So it is not in dispute that investigation is complete and statutory complaint has been filed.
Against the.
This accused. Against the petitioner. As investigation for the petitioner is complete and a statutory complaint already stands filed against him. We find from the list of witnesses and the documents that are likely to be placed for consideration of the special judge that the conclusion of trial will take some reasonable long time. Keeping the being damages spent in custody, when we tell them the fact that co-accused have already been released on bail and that the conclusion of trial will take some time, or without expressing any opinion on the allegations from our direct the release of the petition on bail in the PMLA case also subject to the condition.
Conditions to be imposed by the consent court, Mullah?
Yeah, by this court.
I just wanted one.
Some conditions we have additionally imposed that will also apply here.
Please.
My lords, the one out of state, my lords have imposed on many other occasions. I was only saying I'm a retired person. It's not their case that I have kind of interfered with anything so far.
No,
I
Lord,
was
he has not
available.
cooperated, my Lord.
My lords, I have medical issues, I have heart issues. I leave it to my lords, but I would request my lords can
We will
consider that.
impose that condition because we want uniformity in conditions also. If we take out a case of relaxation, then we will.
Please, Lord.
Very well, my lords, we will.
Please.
Item 10.
We are grateful.
Is there any other matter also? Only 2.
My lords, there are 2 matters. 2.
Item 10 minutes, there is a counter by the other side. Sorry. This according to me will require some hearing. I was just requesting if your lordships will put it for hearing sometime in July or August, whatever date suits your lordships. I'll put in a short rejoinder And my lords, lordships on the last, my learned colleague senior colleague on the last occasion were kind enough to say that till the matter is pending, the trial court will also adjourn the proceedings. My lords. Lordships will recollect this is the company. I am the liquidator of the company.
Lord, it will need a determination and it will take time. My Lord, there's no law covering either side right now. Of course, both are confident about their proposition being true. Put it, my Lord, in July on a non-miscellaneous day for final disposal.
Only thing is the trial, my learned colleague on the last time,
That-
lordships had orally said.
That is between you and me.
Yes, yes. No, I was just, of course, my learned was very gracious with us. August will probably.
So,
Why do we?
so
Next time they
as the matter requires.
I will see.
On 20, first post the matter. Any day available between 22nd or 23rd July.
July, I'll request.
July.
My Lord.
There was one small thing I wanted to say. This is about how IBC code has to be interpreted when there is a fine for a company in liquidation. I was only wondering if IBBI can be implemented at my request so that view will also be before your lordships. Whoever is right or wrong, I have no stake because I am the liquidator of the company. So the insolvency board can also have a say on what should be the correct interpretation.
I don't think we'll need them, my Lord. If my lords do,
Whatever your
we'll see.
lordships
I
say.
don't think we need.
Whatever your lordship.
Let us see.
Yeah, very well. Well, this is my only.
You both being their work perspective also you can highlight.
Yes, they will have another perspective also. Therefore, I thought because otherwise we are all officers of the court because we are the liquidator. Whatever your lordship says, I will do. Milas, I am the liquidator as far as that is concerned.
We'll see with the assistance of both of you can resolve.
Yes, Milas, very well. Grateful to your lordship. Very, very grateful.
On 28th January, I was granted bail in both the matters, EOW and ED. Only in ED it came that I should not be staying. My problem is my son has a heart in the hole and my wife alone is there to look after him.
Lord,
And it has come in the EOW. I have participated.
Lord, the report is of July 2025. Let me file a counter to their application, my Lord.
Whatever.
Because we have to verify
I'm
the
saying is I be permitted to stay in EOW. Lordship did not impose that fine. While passing the order, it was at the end, Lordship confirmed the earlier order, so that condition came into. If Lordship says the order under EOW is on page 22. Page 22, no such, after hearing in detail, no such condition was imposed that I should be out of it. And he is now a 13-year-old boy, Millet, heart in the hole. It can be emergency any time. It doesn't get corrected. That's a physical incapacity which we have to live with.
This was never raised in the main bail application, my Lord, this ground. And the
In the
report
main, we
pertains
came
to
with the writ upon the merits.
report.
We didn't ask for on medical grounds.
Report.
When he gets the child admitted, we'll ask him to submit the medical report.
My Lord, may kindly see, may allow us to just verify it because it's from a private medical.
How will you verify?
From the concerned nursing home or hospital, my Lord.
Better your someone may accompany him when he goes him take to the hospital.
Yes. My wife
That will be
alone.
the latest.
Let him.
That will be the latest report. Huh?
Yes.
May have it tomorrow, my Lord. I'll just take instruction on that, my Lord.
So, what can say for the applicant and learn additional solicitor of India on behalf of the directorate of the question. Say, condition contained in para so and so of the order dated so and so is kept in offense is ordered to be kept in a bench, and the petitioner is permitted to visit his family for the treatment of his minor son, who is stated to be 8 years old and is suffering from a congenital cardiac condition. Requiring continuous specialist medical treatment in Raipur, Chhattisgarh.
Records are of July.
The petitioner shall take the child to the hospital within 1 week with advance intimation to the nodal officer of the Directorate of Enforcement at Raipur. The petitioner shall, after the child is examined by the hospital, after the latest examination of the child by the hospital, they shall submit the necessary medical report, copy of the medical report to the Enforcement Directorate for their verification.
Very well.
In the event of any doubt on the genuineness of the report, the Directorate of Enforcement shall be at liberty to seek restoration of the
My lord,
subject.
may not keep it in abeyance, my lord. His entry, he may notify us. Entry to Raipur or Chhattisgarh may be notified to us. He may go and may not keep it in abeyance, my lord. If, for example, may have it after vacations, my lord. If, for example, he is required to be there for further treatment or
It's not that Eric's heart surgery. This is a condition anytime the child can have, and my wife is alone to look after these child.
medical report, which, because it's raised serious doubt, my lord.
See, if the child is 8 years old, child requires this kind of treatment, then as a father, he has to.
He may not keep it in abeyance. May direct that he will report to us.
Abeyance means that we are not recalled. The condition is there, but condition is kept in abeyance.
Say,
To inform about his entry in Raipur, my lord.
So that's why we are saying that you can always apply if you have any doubt about the medical. Oh.
deeply obliged.
May I, Lord? Lordship,
Lord is
right.
keeping it pending, my lord, is I mean?
No, this point.
The issue of solicium and interest.
Obliged.
Milord, the issue of solicium and interest has already been decided by this court, Milord, in Tarsem Singh, Milord, matter. And Milord,
Instead of filing contempt, where is your matter now pending?
Milord, 34 petition is pending, Arbitration and Conciliation Act, section. Before District Judge Mathura, Milord.
So District Mathura, you request District Mathura to decide it.
Milord, I have given representation. Despite representation, they are not deciding, Milord. In review petition, your Lordship.
34 is pending.
District Mathura, madam.
Lordship, in
When
2013.
your claim for enhancement would be decided, then he will also grant you solicium and interest.
Milord, it will take much time, Milord. 2013 land is acquired, Milord. And your Lordship has directed a review petition when the NHAI has filed. All landowners whose claims the quantum and or component compensation for the land acquired under the NH Act were alive or after 28/3/2008. They were pending before one of prescribed fora shall be entitled to seek addition of interest, solicium and interest of the solicium to their compensation claims.
So where they will seek? Where will they seek that interest and solicium?
Milord,
Where the proceeding is pending?
under section 34.
You take out an application.
Milord, it will take time, Milord. I will only request, Milord, may direct them to consider my representation.
Decide in piecemeal because you have rightly approached the district judge for enhancement. 34 is the right way.
Yes, Milord.
So we can only direct the district judge to expedite and decide, and while deciding, he will also determine the amount of solicium and interest you are entitled to.
Milord,
The land of the petitioner and his family was acquired by National Highway Authority. The petitioner's land, as a total petitioner land in Moza Semri, Tehsil Chhatta district, Mathura, was acquired by National Highway Authority for 6 lane of Delhi-Agra National Highway. The acquisition took place in December 2009 and February 2011. Award was passed by the competent authority on 7th June 2013 without solicitation or interest. The aggrieved petitioner has filed Section 34, a petition Section 34 of the Arbitration Act as per Section 3 capital G in bracket 5 of the NH Act, which is pending before the arbitrator cum district judge Mathura. That is a petition for enhancement of the compensation. Next paragraph. The petitioner has filed the instant contempt petition, inter alia alleging that non-payment of solicitation and interest on the original compensation amount is a willful and deliberate breach of the directions issued by this court in Term Singh 1 and Term Singh 2. So and so. Expera. In our consideration, the appropriate recourse for the petitioner would be to pursue his petition pending before arbitrator cum district judge for further enhancement of compensation. It goes without saying that the learned arbitrator cum district judge shall also determine the petitioner's claim for solicitation and interest in accordance with the decisions of this court relied upon by the petitioner. So, keeping in view the fact that the land was acquired way back in 2009-11, we direct the learned arbitrator cum district judge Mathura to decide the petitioner's claim expeditiously and preferably within 6 months.
Grateful.
My lordships, the question of law and issues in the present petition are already sub judice before this court in the SLP civil number 7649.
Where is the subvention clause?
My lordship, however, there is no clear subvention laws, but it is to be noted that the primary liability was of the builder to give out the possession, and as per RBI circular dated 1st May 2015, the bank had the duty to make the payments stage-wise after due inspection of the construction ongoing. However, the tripartite agreement in this matter was signed on 28/2020, and the payment of 42 lakhs, which is almost 90% of the sanctioned amount of the loan, was dispersed to the builder on within 5 days. That was on 25th August 2020. So therefore, we are not asking here to waiver of the loan, but we are only asking that the present matter be tagged with the already ongoing batch matters, and interim protection be granted to us against the coercive recovery proceedings before DRT 1 Delhi.
What happened in NCLT?
The builders have been already declared insolvent by the order dated 15th April 2024.
Okay. Subvention applies to me. Returnable. What is the date in the other matters?
27th of May.
Issue notice returnable on so and so date, tag with so and so. Meanwhile, no coercive action shall be taken against the petition. Very good, keep it up. Well prepared. That order of attachment can't be passed in your case because already there is a CIRP.
My lord, I am appearing for the petitioner here. My lord, the children of 10-year, 11-year, 12-year, they are made, they are used in the orchestra, in the dance bars. And my lord, as far as the spa and massage parlors are concerned, some of the states have made the rules that it should be 18-year plus. At page 139, annexure P12, I have a next. My lord, in Delhi, in Tamil Nadu, and in please.
Mr. Fulka, it's a very serious issue. We would like to issue notice. We would like to.
Yes, my lord. So grateful, my lord.
Issue notice.
For item number 50, I'm seeking a short passover. For item number 50, I'm seeking a short passover.
It's a short issue just for appointment of an arbitrator.
I'm led by my.
Substitute arbitration.
Just for appointment of a substitute arbitrator.
He's appearing for respondent. If he is
I appear for the petitioner.
You are appealing for the petitioner. Who is appealing for the respondent?
The arguing counsel is in another court. So.
No. Are you assisting the same?
No. No, it's for the petitioner. I'm for the respondent.
You are for the respondent. Don't get stressed. Be relaxed. There's nothing we are doing that. The only request is, as Justice Bopanna says, that I may be recused because he does not want to do arbitration. So why don't you suggest some other name?
Anyone from Karnataka High Court?
Justice Ravindran, my lord, because the arbitration clause mandates an appointment of a retired judge of the Supreme Court of India. So we informally sought his consent. He's agreed. Justice Ravindran is based in Bangalore as well.
Any issue?
No issue.
We hope that Justice Ravindran's health is fit and fine.
Yes, my lord, he's hale and hearty.
Very good, very good. So, that's all.
My lord, I am item 60 and withdrawing.
Completely frivolous petition.
I'm withdrawing
It's
this
coming up on 28th, my lord, 29th for hearing, my lord. And he is preempting something. He is filing a PIL challenging the appointment of the Secretary of Ministry of IUs because he has done cleansing in the department, my lord. Now he is pursuing there and then he has filed this SLP when the matter is fixed for hearing on 29th itself, my lord.
I am withdrawing this matter. Yes. I'm withdrawing this matter.
Hello.
Grateful. I'm an advance notice, my lord.
Yes.
Physical appearance.
Mark the additions received. Item 17.
Yes. Lord, this was the case of a tender. And I have come against an ad interim order, but Lord, the facts are shocking. I want to, Lord, just Lord, note two facts. This is the toll collection case, Lord. There is a tender, Lord. In the tender, Lord, I am the highest bidder. If your Lordship will note, Lord, on a per day collection, something important.
But there is a huge gap, Mr.
I know, Lord, I'm coming to it. If it was the case of huge gap, my Lord, your Lordship may dismiss my case right now. My Lord is seeing the gap because what I bid was 2 crore 32 and this is now 5 crore, Lord. That's the gap. The actual reason is this, not this, my Lord. The actual reason is I was the highest bidder at, my Lord, 222 or whatever. On the same day, I'll tell you the reason. I will tell you, Lord, the Chief Justice's question is the most important question. Why this double gap? My Lord Chief Justice's question is, why the double gap? My Lord, on the same day, when the highest bidder is at, my Lord, 226 crores, on the same day, you cancel it and put a reserve of 555 crores, which is double. There has to be something shocking. What has happened on that day and this day? The reason is this.
No, nothing is shocking. They don't want a tender to come because the existing one is continuing.
Simple. That is the ground I raised, my Lord. He is at 47 lakhs a day. I am at 62 lakhs. So 47 lakhs was allowed 3 months in November 24. We are, my lord, in middle of 26, and I have said it very clearly, as Justice Bhakti pointed out, my lord, this is what is going on. The High Court doesn't see through it.
But the only thing is, suppose now that tender has been issued.
Right.
If
I'm saying one more thing.
There's nothing to
One
this. It's
second, please.
absolutely incorrect what is being said. It's the matter on 8 June now.
That doesn't matter if it's on 8 June.
Vacation bench has said that, look, we are making it subject to further
Subject means
orders.
what, Lord?
All
This is
participants,
absolutely
we can
gross.
participate. All participants are to do it.
Not at
File
all.
your reply. We have filed our reply so that there is
Would you
no
not
delay.
just
Now it's
allow
kept
me?
on the 8th of June.
This is, my lord, this is a gross.
And there are very strong reasons why.
Gross scheme which is going on. Turn to page 3 for one second.
The point is, Mr. Rohgi, now that tender has been floated.
Yes.
If someone comes with an offer of say 530, 550, whatever it is.
No problem.
Minimum.
Give it. But if, my lord, they scrap this tender because nobody will come at 550, I know. Then your lordship will record that that fellow must stop. He can't go on. He can't go on like this. Now this fellow, my lord, now.
You propose to modify this injunction.
Yes.
What they permitted is without prejudice to your rights, you will participate.
Yes. Yeah.
Let the tender be subject to the writ petition.
Your lordship must do that. And also, if this tender is scrapped for some reason, then the ad hoc chap,
Yes,
my lord,
yes,
who's
everything
continuing
will be
at a
subject to
much
this writ.
lower rate, he has to stop.
It's already provided for. Your Lordship, may clarify that. Please just see
Because the High Court has not seen through the game.
There's no game.
This
Just
is a
see,
game, absolute game.
in our
There is no
considered
game.
view, the interest of justice would be met by
There is no interest
subjecting
of
the
justice,
fresh.
Lord, which is going on.
Please see the last line on page 6.
And this, my lord, this man has quoted 186. My bid was 222, increased to 232 in negotiation, then cancelled. He is at 186, and now the demand is 550. I am saying if they're not going to get 550.
Itself is subject to the writ petition.
Yes,
I'm saying
please
something else.
expressly made.
1 minute, please. I'm saying something else. If they've cancelled this contract, my lord, for not getting 550, the first thing they must do is to, my lord, remove that interim guy who's continuing, my lord, for 1.5 years at a much lower rate. Appoint somebody else as an interim person.
If they do not get a bidder
Yes.
up to 550,
Yes.
your case, in fact, is established before
I
the
agree.
court.
But, my lord, they are all mixed up.
Be entitled.
They are not going to go by this law. They will say, sorry, your tender is out. Forget it. Now we are on a new wicket. New wicket, somebody comes, doesn't come, we will not continue that chap. This is what their game is.
Mr. Rodgi, they have to demonstrate some cogent, compelling reasons for cancelling the previous bid. No doubt, a concluded contract had not taken place.
Correct.
But within 1 month, going with a higher.
On the same day, my lord, you after negotiating with me, you
permitted them to negotiate with you to increase your bid.
I did.
And you were participating.
Lord, I was called for negotiation. I increased it, my lord. The law is, this is something, my lord, just a game which these officers are playing. Bids. 29th
of
they are asking me to bid without prejudice.
Yes.
They are asking on 29th. The reason given for cancellation of my contract is administrative. What is this administrative, my lord? Only, my lord, to continue that fellow.
We have filed
I am
reply.
saying, my lord, one minute, please. I am saying 8th June, my lord, is not far away. 8th June is not far away. My lord, prior to decision of the court, they should not finalize. Another third party will now come in. So let them look at it on 8th of June today, my lord. When the game is this, to allow that man to continue.
Maharashtra State Road Corporation.
Yes, I'm for R1 and R2.
So you have to finalize the new tender.
I have to?
You will finalize the new tender.
Yes. Yes.
29th is the last date.
Yes. For receiving bids.
How soon will you be able to decide?
I've not taken instructions on that, but it's bound to take some time. It's bound to take some time.
How much time? Because
I will make a statement that I will not make any award before the 8th of June, which is the next date of hearing. But it is not to be construed as a stay. I'll make it very clear, because I'll tell you what's happened. We have filed a counter affidavit in the High Court. What had happened here was that there was a study which was conducted. That study showed a huge surge insofar as traffic is concerned on that thing. So therefore, on the basis of that traffic study, the authority found that because there was such a huge increase in traffic between November, I think the study is between November and March, April 2026, there was a need for going through with a new tender because the reserve price had to be increased. So there was a massive loss. So there was a whole foundation for this. We have placed this on affidavit. Because now I am suggesting,
completely wrong, Milord.
see, if you are earning a little more exchequer, we have no difficulty with that.
That's what has happened. That's what the estimate is.
The concern is that ultimately, suppose you don't get anything, and a person who
Milords, I am saying it will be subject to, it will be subject entirely to the orders which are final orders which are passed in the writ petition. The writ petition is coming up on the 8th of June. When the court considered in paragraph 19 of the impugned judgment that, look, should we change the dates? They realized that this is a pivotal infrastructure project for Mumbai. Since it's a pivotal infrastructure, the correct and appropriate order, which I am also commending to your lordships, is that, look, all further action will be subject to final orders passed in the writ petition. So they will examine our reply. If they are satisfied, there is no question. My learned friend is making allegations about some third party. He has not even implemented that third party in the writ petition. I just saw the court title. So where's the question of malafides, etc.? So you just make an oral submission as you like without even implementing the party. It's not even, he's not implemented him as a party respondent. And that person, let me tell you, is not conducting the, because your lordship's apprehension was that is there some tender being automatically extended. That is a separate issue. That's a commission basis. So MSEDCL is drawing the money. He's only getting he's only receiving a certain fixed commission.
47
and in
lakhs.
any case, we want to complete this the earliest, and we want to make a quick award as far as this particular tender is concerned. So, Manoj, please don't interdict. The matter is coming up on 8 June.
I can show Milord, this study argument is completely bogus. As per their study, the figure is 62 lakhs per day, and I have offered 63 lakhs. What are you talking about this study? Administrative reason. Then you would have said, this study, Milord, was prior to the issue of this tender. From 62 lakhs per day, I increased to 63.5 lakhs per day. And that fellow is continuing at 47 lakhs. This is the way, Milord.
Different study. There were two
Absolutely,
studies.
Milord.
Anyway, that we'll place on reply, etc. But I would
They will finalize
please
without
don't
the legal
interdict this entire process. Let it go through subject to orders. Subject to final orders. And we can make a request to the High Court to take it up on the 8th immediately.
The Supreme Court will make it an order.
The instance which will be taken up directed against. And swear a motion to 15th May 2026. Passed by the vacation bench of the Bombay High Court. In terms whereof
January to May to May, sir.
interim stay on the tender cancellation original to 29th April 2026 has been declined. So, by safeguarding the interest of the petitioner, the two conditions that the petitioner may participate in the fresh tender process without prejudice to its rights, and that the first tender floated by the first and second respondents on 29th April 2026 shall be subject to outcome of the petition. The matter is now before the High, next paragraph. The matter is now listed before the High Court on 9th June 8th June 2026. Next paragraph. We have heard about the counsel on behalf of the petitioner and the Diwan and counsel for the counsel on behalf of the Maharashtra State Road Development Corporation. We are informed that the last date to submit the press tender is 29th May 2026. So, having regard to all the attending circumstances, we direct the Maharashtra State Road Development Corporation to finalize the press tender subject to the conditions imposed by the High Court, before 8th June, by 8th June 2026, and submit a report on the sealed cover before the High Court.
Very well. Very well.
The follow-up action will depend upon the outcome of those proceedings.
Grateful. Grateful. Sealed cover.
Because after the first FIR was closed in October, 12 FIRs across 4 states, Manoj. I'm really running from pillar to post. Manoj, if your lordships are not inclined, can I withdraw to seek other appropriate?
Our view,
We are not inclined in these sort of cases to club the FIR.
Well, let's make, your lordships will permit me to withdraw to seek other appropriate remedies.
Yes.
Very well. Very well.
Full कर दिया.
What voice is good?
Lord, this petition seeks regular bail. But Lord, have a look at my chart. This is a case of evergreening. Whenever I am in, out, I've got bail everywhere. So Lord, now 2.5 years have gone by.
Scam altogether. Malas, this is a different scam altogether.
Oh, wow.
And sir, but when was the trap? When was the trap? November 23?
Absolutely.
When was the FIR?
24.
November 24. Why? A person, you are right. This is with regard to a different aspect of the liquor scam.
Absolutely.
You are absolutely right. This is with regard to human resource.
Yes, please.
There, the liquor itself was being manipulated, money was being made. Human resource is being manipulated.
So this is a manpower
arrest from Eagle Hunter is on November 23.
Yes, please.
Till ED tells you, you don't lodge an FIR.
Malas, this was not in the.
It's not that at that time these people had the control over the state administration.
Malas, the issue.
Lord, 7 charge sheets have been filed in the liquor scam. Now you take out another FIR.
Back then, in October 2023, Malas, the accused here had a political patronage, Malas.
What political?
Malas, he
had no political patronage.
Malas, the state, ED had, but the state was informed and the state chose not to register the FIR. It's only when ED wrote subsequently again.
The state was not aligned with the principal conspirators as you allege in 2023. We would have completely agreed with you if the political executive of the state had been replaced in the meantime.
Yes, Malas, it has been.
No, not in 23, earlier, in 21.
No, Malas, the political regime changed in December 23. And that's why, because.
So, even if you see December 23, see, October 24 is the registration of the
FIR. Yes, please.
What is this?
So after, Malas,
every 6 months there's an FIR. Every 6 months I have to take. We'll just have a look at it.
Only this scam, Malas,
kindly just pass it on.
Been perpetrated in Chhattisgarh. Same Same modus operandi was also, no, not UP, my lords. Here in Jharkhand, my lords. My lords, may give us 1 week time, my lords, we'll file a.
Just have a look at this.
Same.
Just see this.
May at least give us time to file a counter, my lords.
May see this. Now the liquor scam, my lord, ECIR of ED is of 22, date of arrest 23, FIR liquor EOW, date of arrest April 24, FIR liquor UP, date of arrest 18 June, same facts. ECIR for liquor ED for UP, 8th of August, FIR, my lord, rice EOW, 9th of July, every 6 months, my lord, we done. I got bail.
We are issuing notice.
My lord, I'm pleading for interim bail. My lord, this is not subject to any condition.
Give us 1 week's time, my lords, we'll file a counter.
One second, please. This is a gross violation of Article 21, my lord, to do this again and again and again. My lord, give me interim bail, give it after 2 weeks.
We'll ask them to file reply by Friday.
Yes, my lords, we'll
And on 1st June, Monday.
All right.
We'll
Let's do that.
file the reply by.
But I would prefer if my lord, the Chief Justice takes it on Friday.
Can it be?
Give it, my lord, they will reply by day after.
My lords, can it be on
39th?
First. My lords, I am in personal difficulty.
Ceremonial benches and.
Lord, I would submit, my lord, it should be before your lordship.
Third.
Chief, first we bed.
Well, your lordships are sitting in the first week because the other matter of mine also your lordships were pleased to put on the first week.
No, there will be bench available. We may not. Bench also notified already.
Benches are not notified.
No, notified.
Not notified.
Not yet.
Mr. Passing, is it not notified?
Benches have not been notified.
Benches have not been notified.
Benches are not notified.
From my side, I have cleared.
It has not, circular has not come.
Circular.
So some judges have told me in court that they are sitting in the first week. That may not,
Yes,
that way, but not.
I also know, but otherwise.
Benches are available throughout the Kalki working days. Sufficient benches are there.
Very good.
So you file the reply issue numbers 32 item 32 and 32.1.
32.1, there is a.
First, I'm in personal difficulty, my lords. My mother may get operated on first.
First, second,
Third, my lords, if my lords may keep it on third.
polite on third. On third floor.
Same bench.
In 32.1, Lord, there is it should not have been actually tagged. It is the same FIR, but here grounds of arrest were not given, admittedly not given. Orally informed, grounds of arrest, signature taken.
Item 32.1.
32.1. If your lordship have not read that, Lord Lordship have it tomorrow. Otherwise, Lord, this is a
We'll file a
separate case.
counter, my lords, on the same day.
Both.
No, grounds of arrest is not given, Lord, your lordship. Several, not one, but two judgments of this court. Lord, now your lordship says 2 hours before the remand is filed, you have grounds of arrest has to be given. Justice Vikramnath also in the recent judgment.
It has been produced within 30 minutes.
No, 1.5 hours. But no ground of arrest.
Say that is in breach.
But Lord, the
2 hours when the detention prior to production is more than 2 hours.
2 hours.
Consider this case. Will you press on grounds of arrest or will you ask for bail on merits?
No, I'll consider both, but I'll tell your lordship.
So if you consider both, it would be better for you to withdraw this and file a bail application before the High
Can
Court.
I say this, Lord? I'll be able to send
Consider
on this. That this is a case where, admittedly, let me assume grounds of arrest 2 hours because of your lordship is like 1.5 hours. But grounds of arrest in any case should be given to me. That is not given to me. Admittedly not given to me. It was served finally to me along with the charge sheet on 18th of May after the filing of this petition also.
We'll verify, my lords, and
file counter.
We'll file counter, my lords. May keep this matter on third.
But would your lordships keep it this side of the vacation because
Practically not possible because 28th is holiday. 29th again ceremonials and
then let it be. Then he'll take only third only. Then.
on 3rd June we are keeping.
Then along with the other matter.
Yes, both matters.
But let it not be tagged, Lord, because then your lordship.
No, this should not be tagged. It will separate.
It's actually separate.
Point is completely different. We don't know why.
Deeply obliged.
So listing.
Today also in another court, Lord,
Actually, today in another court also. No,
Yes,
Lord,
yes,
that's
same
not
affair.
the issue.
That is right.
Somebody should analyze. In another court, Lord, there was a criminal matter and a civil matter. Some parties were common. Tagged. The judges have not read the other file. So that's a serious problem. Somebody responsible
So there
should
was one
see.
matter where it was brought to my notice that a criminal matter has been tagged with civil matter. But then I immediately tried to find out. There was a statement made by some young counsel that this matter should be taken up along with those.
No, not in my matter, Lord. Not the matter which I
That happens
abuse
in
some other, because of which, Lord, the learned judges have not read the file, so it is kept separately. That becomes a problem. Deeply obliged, Lord. Third then.
Separately.
Your matter, we had read the file.
Very well. That I could take on, Lord, from your Lordship's comment. Deeply obliged.
Item 33.
May I please, Lordship? Lordship, this Honorable Court order dated 27/4/2022 constituted the committee, Lordship, identified the beneficiaries throughout the nation. But the past 4 years that is in committee is not
Modified.
Entertain this kind of.
Lordship, that is in past 4 years that is in completed, Lordship, some time limit, Lordship, that is.
Millards, 34, I beg to appear, Millards. This has to be tagged with the other matter.
Other party has.
But Millards, the interesting case is my JV goes up in appeal first. Appeal gets allowed on identical facts.
See the cross case.
Yes.
Issue notice tag to be taken up along with CAD number 15918/2020.
Grateful, Millards.
Yes, Mr. Sahib.
Lordship, the contempt petition is brought in the light of order passed by the Honorable Apex Court of India dated 18/11/2024. So Lordships, it goes without saying that the appropriate forum shall consider such a claim in accordance with law and shall not be influenced by the impugned orders of the High Court merely because the petitioner chooses to adopt an erroneous recourse for determination of his right to compensation ordered accordingly. Lordship, the arbitrator has assumed that no order has been passed by the Honorable Apex Court of India. The order passed by the arbitrator can be compared with the order passed by the Honorable
Supreme Court. Mr. Sahib.
Lordship.
Earlier we dismissed your petition saying that it was not maintainable. But at the same time, we allowed you to approach the prescribed authority, right?
Lordship.
After that, you have approached that commissioner who is the statutorily prescribed arbitrator under the Act.
Lordship.
Your claim for determination of compensation is pending before that authority.
No, Lordship. The matter has been disposed without giving notice to the respondent.
Then challenge that order, please. Challenge that order. What is the contempt? You are a lawyer.
But Lordship, there is the question that they have defied order of the Honorable Apex Court of India. Order Supreme Court का कुछ उन्होंने लिखा क्या है? The division bench was of the view क्या है? Supreme Court के order के साथ they have played.
Sir, what happened to your matter in the before this commissioner?
Lordship.
What happened in that matter which you filed before the commissioner as an arbitrator?
The commissioner has finalized the matter, Lordship. The commissioner has finalized the matter.
Finalized the matter. So some award has been passed.
Award has been passed.
Award might be against you. Award may be in your favor. Award may be partly in favor, partly against. Challenge that award.
Lordship, question is this. I approached the Honorable Patna High Court under Article 226. The petition was dismissed. I approached under Article 32 in the Honorable Apex Court of India, claiming that my fundamental rights have been infringed under Article 14, 21, 31 a proviso. That was dismissed, and I was given some words of the Honorable Supreme Court, like the purse and diamonds for myself, and now all have gone in vain.
Please understand, you are an advocate. It's your personal matter. When you argue unnecessarily, you sometimes get confused.
My lord, I am carrying my pyre. आखिरी blood खत्म हो चुका है.
And by a tell us, What can we do now?
लॉर्डशिप उनको बुलाया जाए, पूछा उन्होंने ऐसा किया क्यों?
क्या बुलाकर क्या पूछे उनसे, बताइए।
लॉर्डशिप उन्होंने सुप्रीम कोर्ट ऑर्डर के साथ ही खिलवाड़ किया।
सुप्रीम कोर्ट ऑर्डर, अगर उसने आर्बिट्रेटर ने कोई अवार्ड पास कर दिया है, मान लीजिए आपका क्लेम उसने रिजेक्ट कर दिया,
बस
तो आपने बता नहीं रखा इसमें, हम अंदाजे से पूछ रहे हैं, उसने क्लेम आपका रिजेक्ट कर दिया, तो उसको चैलेंज करो आप।
लॉर्डशिप हम कहाँ जा सकते हैं?
अरे भाई, आप एडवोकेट हैं, आपको तो आपको क्या प्रॉब्लम है?
एक बार उनको बुला के,
तो बेचारा गरीब जमींदार को तो, गरीब किसान को तो, आपको क्या प्रॉब्लम है?
लॉर्डशिप हमें मिला क्या? आखिर यही तो मिला था जरा सा, और इसके
तो
साथ भी लॉर्डशिप
कहीं कोर्ट में जाएंगे, चैलेंज करेंगे, तो आपको कोई आपके कानून के, आपको जो आपका बनता है मिल जाएगा आपको।
लॉर्डशिप हम तो मर जाएंगे, हमारी आने वाली पीढ़ी भी मर जाएगी, इसमें पैसा कहाँ है? लॉर्डशिप ये सोचा सकता है लॉर्डशिप कि आर्बिट्रेशन एक प्रक्रिया नहीं है, आर्बिट्रेशन
आप
एक
बहस
मिशन
करते
है।
हैं तो आपके
लॉर्डशिप
सारे केस जीतते होंगे, आप इतनी भावुक होकर के बहस करते हो तो
नहीं
कोर्ट भी बड़ा कंप्रेशन में आ जाता होगा।
नहीं, सच है लॉर्डशिप,
नहीं होता होगा।
बस लॉर्डशिप अपनी अर्थी को ढो रहे हैं, माफ किया जाए। उनको बुला के पूछा जाए कि उन्होंने ऐसा क्यों किया, देखा जाए कि उन्होंने ऑर्डर में क्या लिख दिया। ऑर्डर यह है, उन्होंने लिख दिया कि द डिवीजन बेंच ऑफ द व्यू। अब लॉर्डशिप
वो ये बोलेगा आकर क्या में कि जी मेरे अंदर तो जितनी बुद्धि थी, जितना मुझे आता था कानून, मैंने तो उसके हिसाब से ऑर्डर पास कर दिया, अगर इनको मेरे ऑर्डर से कोई समस्या है तो बड़ी कोर्ट में चले जाएं। क्या जवाब देंगे हम उसको?
लॉर्डशिप जनरल को उसमें वहां हम जाते तो नहीं था।
उसको बोलेंगे आपने साहिब साहब को नाराज किया है, इसलिए हम कंटेम्प्ट में अंदर कर दें आप।
लॉर्डशिप हम सुप्रीम कोर्ट आए हैं, और ऐसा कोई आर्बिट्रेशन होता है लॉर्डशिप कि उन्होंने रिस्पोंडेंट को नोटिस तक नहीं किया, और आर्बिट्रेटर इज नॉट लेस देन IAS ऑफिसर। लाल बहादुर शास्त्री अकेडमी में उनकी शिक्षा हुई है। लॉर्डशिप हम इंग्लिश बोल सकते हैं, माफी चाहते हैं, लेकिन चूंकि हम काफी घबराए हुए हैं इस उच्च वातावरण से, और
इस वातावरण से आप घबराएंगे? वातावरण तो आपका रोज का देखा हुआ वातावरण
नहीं,
हम क्यों घबराएंगे आप?
लॉर्डशिप पे थोड़ा सा पढ़े हैं, लेकिन इतनी ऊंची बुद्धि में
साहब, आप बात सुनिए, आप कितने साल से प्रैक्टिस करते हैं?
लॉर्डशिप प्रैक्टिस तो कर रहे हैं 2004 से, लेकिन सच है लॉर्डशिप की इस प्रोफेशन 2004 से
2004 से 2004 से आप प्रैक्टिस कर रहे हैं साहब
जी,
तो आपको पूरे 22 साल प्रैक्टिस करते हो गए
जी।
आप किस बात के लिए घबराएंगे?
थोड़ा सा घबराहट होती है। हमने सच बयान किया है, झूठ नहीं कहा है। लॉर्डशिप सच ये है कि सुप्रीम कोर्ट के ऑर्डर उन्होंने खिलवाड़ किया है, तो हाउ डेयर ही डिड सो, इसलिए उनको बुला के पूछा जाए, हमारा कल्याण हो जाएगा।
साहब अंडर वो आपका जो है ये नेशनल हाईवे एक्ट है, उस एक्ट में वो एक स्टैट्यूटरी प्रिस्क्राइब्ड अथॉरिटी, राइट
लॉर्डशिप,
वो एक स्टैट्यूटरी अथॉरिटी है जिसको एक्ट में ये पावर है, उसके पास ये शक्ति है, उसको ये संज्ञान लेने का वो है, उसके पास ये अख्तियार है कि वो आपका डिटरमिन करेगा कि आपको कितना कंपनसेशन मिलना चाहिए। हो सकता है आपके हिसाब से सिंबॉलिकली बता रहे हैं, मान लीजिए आपको लगता है कि आपको 1 लाख रुपया मिलना चाहिए, हो सकता है वो आपको 50,000 रुपये दे, आपका एग्रीमेंट जायज हो सकता है, लेकिन वो जो कानून में जो प्रक्रिया है उसी के हिसाब से करोगे ना।
लॉर्डशिप यही तो हम भी कर रहे हैं कि पैसे का सवाल नहीं था। लॉर्डशिप एक बात, पैसे का सवाल नहीं था, सवाल यह था कि उन्होंने
पैसे का सवाल नहीं है, क्या सवाल है फिर? आपकी उसने भावनाओं को थोड़ा सा कर दिया।
लॉर्डशिप सवाल यह है कि उन्होंने आर्बिट्रेशन प्रोसेस को पूरा ही नहीं किया। इसका सेक्शन 21 देख लिया जाए, आर्बिट्रेशन कॉन्स्टिट्यूशन एक्ट कहता है कि बिना रिस्पोंडेंट को नोटिस के यह हो ही नहीं सकता है, नहीं इस पर एग्रीमेंट हुआ, नहीं किसी का आर्गुमेंट हुआ, बैठ के टेबल पर बैठ के उन्होंने ऑर्डर पास कर दिया।
उस एक्ट में नेक्स्ट अथॉरिटी कौन है? एक्ट में नेक्स्ट अथॉरिटी कौन है? नेक्स्ट
अथॉरिटी तो फिर अब जो है जिला जज है, इनके खिलाफ जाना पड़ेगा पंचायत के पास।
डिस्ट्रिक्ट जज होंगे मेरे ख्याल से।
जी हाँ, डिस्ट्रिक्ट जज है
वो 34 का, क्योंकि ये है ओरिजिनल डिटर्मिनेशन। कमिश्नर जो करता है वो पावर है तकरीबन सेम पावर जो लैंड एक्विजिशन कलेक्टर की
जी।
उसके बाद 34 की पावर है वो है डिस्ट्रिक्ट जज के पास। वहां जाइए, डिस्ट्रिक्ट जज के क्लेम डालिए, हम डिस्ट्रिक्ट जज से रिक्वेस्ट करेंगे, उसको थोड़ा सा आदेश भी देंगे कि आपके क्लेम को जल्दी डिसाइड करें।
लॉर्डशिप यही आदेश कर दिया जाए, जो दे दिया जाए, हम क्या कर सकते हैं, लेकिन लॉर्डशिप क्या ख्याल रखा जाए? आखिरी बूंद
का केस नहीं बनता आपका शाही साहब।
लॉर्डशिप आखिरी बूंद खत्म हो चुका है, जिला नवादा हमारा है, आखिरी बूंद खत्म हो चुका है, मर रहे हैं हम। आई एम फेसिंग स्टारवेशन। 3 कट्ठा जमीन गई है लॉर्डशिप, जो कि एकदम सड़क पर की जमीन गई है।
और सरकार डेट है जिस दिन कमिश्नर ने ऑर्डर किया, उसकी डेट क्या है?
जी, उसका डेट है 23 फरवरी 26, 23 फरवरी 26 है।
इसको चैलेंज नहीं किया?
जी
इस ऑर्डर को चैलेंज नहीं किया आपने अभी तक?
जी नहीं, चैलेंज तो नहीं किया लॉर्ड से।
क्या करते हो शाही साहब आप? दोनों या दुनिया को आप कानूनी सलाह देते हो और आप अपने मुकदमे का ध्यान नहीं रखते।
लॉर्ड से हमें भरोसा था ऑन सुप्रीम कोर्ट में जाकर।
23 फरवरी का ऑर्डर हुआ है, आज मई खत्म होने को आ गया, आपने लिमिटेशन का ध्यान दिया कि नहीं दिया?
यहाँ लिमिटेशन 90 दिन का था, लेकिन हमने तो 10 अप्रैल को ही फाइल कर दिया था यहाँ ना पिटीशन।
आप जाइए इसके खिलाफ चैलेंज कीजिए। So we have heard the petition in person. The incident contempt petition has been filed on the premise that the commissioner cum arbitrator under the National Highway Act on the premise that the regional commissioner cum arbitrator from a Magad division, Gaya Ji, Bihar, has not followed the directions of this court while passing an award on 23rd February 2026. It appears that the land of the petitioner, comprising Khata number 77 in village Repura, Omar Avenue Circle, Maskur, Nevada, Bihar, was acquired for construction of NH 84.4. The compensation amount was determined, against which the petitioner filed a petition that the petition was disposed of with the direction that the petitioner grievance be considered by the commissioner cum arbitrator under section 3 capital G in bracket 5 of the National Highway Act. Instead of availing that remedy, the petitioner firstly filed an intra-court appeal and thereafter a writ petition before this court. The said writ petition was dismissed being not maintainable, though the petitioner was granted liberty to approach the prescribed authority for award of just and fair compensation. Thereafter, the petitioner approached the divisional commissioner cum arbitrator, Magad Division, Gayaji, and as noticed at the outset, his claim has been, his claim for enhancement has been turned down by the said authority while an award dated 23rd February 2026. Next paragraph. As the facts would speak for themselves, the appropriate reports for the petitioner for the purpose of seeking further enhancement is to challenge the award dated 23rd February 2026 before the prescribed forum. We see no ground to initiate the contempt proceedings against the respondent authority. The petitioner, advised may challenge the award dated 23rd February 26 before the appropriate forum. Yes, we can taken to be serious pursuit that spent by the
I am appearing in 36.1.
pursuing the instant petition may be directed for the purpose of communication. आपने देखा है सब? Yes, Madam Pooja, what happened?
Yes, my lords, I'm appearing in 36. This is a Navy matter.
I am appearing in 36.1. It's an army matter. So there's a little difference, but I'll
whatever. If she wants to do her case first, it's all right.
So, my lords, I am only relying upon, ma'am can do her first. That's
So,
okay. Ma'am, please do.
This is an
Ma'am,
army
can you-
officer, lady officer, who had put in 15.5 years. When she completed 14 years, the judgment of the High Court in Babita Punya was there. That judgment was not stayed. They were bound to give me permanent commission, but they told me we will not give you permanent commission since the matter is pending in the Supreme Court. Now, my lords, I'll show my lord the order which said, this court said there is no stay at all. But still they said you come on extension only. And they, after giving her extension, she worked for some time. And then they threw her to Kashmir with a 3-year-old daughter because they were against her that you are not wanting to take. Now, she says, all right, I will leave the service and go. They ask her to give an undertaking. She gives her undertaking. Within 1 month, she goes and says, now, please reinstate me. I will go there also. They don't take her. Now, this court, Milos, has given people who have done 14 years service without being considered for permanent commission, at least pension. I'm not today saying if they can get
That,
Milos, I'll show the judgment. Milos,
no, these are two separate matters.
yes, but they are all, I think I'm not sure about her facts fully, but in my case,
So are you arguing this lieutenant,
I'm arguing for Lieutenant Colonel Ravneet. Yes, Milos, she's put in 15.5 years and within
Ravneet case?
Milos, Army.
Yes. You are arguing Ravneet case?
Ravneet case, Ravneet. Milos, I'm arguing that case. And Milos, my submission is if they don't implement the judgment of this court.
After 2019, what action did you take?
Milos, 30th January 20, I was before them, and 21, I had filed my OA also. My OA remained pending. In fact, when my Lord's judgment came, my matter was pending. In fact, we had filed it. Just 1 second.
You are virtually asking deemed service for pension.
No, sorry, my lords.
In your matter,
Yes, my lords.
you are asking now.
My lords,
Extension,
if I may just, I am relying on the direction of Annie Nagaraja. My lords, I have extracted in my synopsis on page C, direction number 109.11. My lords, direction number 109.11, if I may read, it categorically stated that as a one-time measure.
Voluntary retirement.
No, my lords. I was there. My OA was pending. If my lords may see, my OA for grant of PC was pending from 2017. So as on Annie Nagaraja, I was also in court. I'll show you my prayers. I'd asked for PC.
In fact, despite the judgment, they were not willing to give us. That's the problem. Despite the judgment not being stayed.
In fact, my lords, learned AFT has granted pension to my course mates also. And my lords, if my lords will see 109.11 categorically stated that anybody who is present before the AFT or High Court will be granted pension. I was granted pension. I was in court since 2017. My OA was 2017, asking for permanent commission.
Please,
Obliged.
Regarding item number 37 and 38, my lords, these matters pertains to the builder, buyer, and the bank agreement, the tripartite agreements, my lord. So these also needs to be tagged, my lord. Only, my lord, in item number 37. My lord, only in item number 37.
Subvention clause in your case also.
My lord, then there's a tripartite agreement, my lord. So these are the other batches, my lord, and my lord, in tripartite agreement. My lord, in item 37, recovery proceeding is being initiated. So just on 37, we state.
What happened to the builder is also in CRP?
Yes, my lord, CRP and the CBI investigation is also going on, my lord. In 37, my lord, stay with the recovery, my lords. In 37, the recovery proceeding is going against.
You have said that no.
I'm so grateful, my lords. 38 also, my lord, the same. 37 and 38 both were the same matters. Grateful, my lords.
May it please, Smash. shocking situation where this section itself admittedly doesn't apply. If my lords will just have section 8 of the PMLA, it's very, very clear in terms what adjudication is. If I may read that, PMLA, section 8, my lords. On receipt of a complaint under subsection 5 of 5 or applications made on the so and so, if the adjudicating authority has reason to believe that any person has committed an offense under section 3 or is in possession of proceeds of crime. That's it. These are the two triggers. If your lordship sees what is the appeal which came before the High Court, just see page 626. This is the stand of the ED itself. Page 626 for a minute. If I can just read para 10. This is their stand in their appeal regarding me. Because I'm a bona fide third-party purchaser, they admit that they have no case against me. This is their appeal, page 626, para 10. If I can just read that.
Value thereof.
That's the problem. Just if I can just show you. The only thing that they can proceed against,
Value thereof.
the money is sitting with the company. I am a bona fide third-party purchaser. There are 75 flats that were put up for sale. Just para 10, page 626.
Matter where notice has been.
Well, very well.
Very well.
We have taken a shortcut.
Mrs. Brunton Developers.
We don't want to exert ourselves. Lordship has an order. Kindly. Well, this is incidentally a house I'm living in. It's a. This starts in 16, and the actual attachment takes place by the impugn order in 2025. I'm living for decades there.
Dr. Singh, the High Court has indicated certain aspects.
Well, anyway, your lordship will tag it will satisfy my lord.
Which are
Lordship will
required to be gone in.
Very well. Your lordship will tag it.
But I mean, just to satisfy the conscience of the court, at the very outset, we were told that I'll get a 1.25 crore discount, 1.4 crore discount if I pay upfront. So I paid everything upfront. And this is for 75 home buyers who did it, and you choose 6 or 7 to come again. I mean, what?
Your lordship may tag it. Only one thing is that status quo as of today. I'm living there for decades.
Yes.
Status quo as of today. Man.
No.
Status quo as of today.
Okay, you won't take it.
Like.
Well, there's a delay which may be condoned, 88 days, because of the review we had in between. Well, I'll just give an undertaking. I won't create third-party rights because our High Court's judgment stands in the way. Because the attachment order was set aside by the PMLAT. The High Court's order effectively reverses that. I'm giving an undertaking. I won't create third-party rights. Your Lordship may just note that.
Even if you are in possession, sir.
Yes.
Even if there is an attachment, it's a symbolic attachment.
The problem is there are many other procedures. The official liquidator and the banks are coming after this property, after which there was on consent a sale deed which was issued in my favor. For the High Court, I just wanted your Lordship to see that paragraph, that para 10 of the appeal. Specifically, it's shocking that after that they can proceed against me. This is their stand. I'll just read it out. The provisional attachments were made on the premise of property equivalent to proceeds of crime.
Value thereof.
No, I know, but that value thereof has to be of the person accused. I'm not an accused. And it was never alleged at any stage that the respondent was involved in the crime.
And that's why we said these are issues may go into utter notice because you had no enforceable right created by handing over money.
No, I'm sorry, my lords. I had the allotment that was granted to me.
At performance.
Yes.
Payment of money, will it constitute a written agreement creating an interest in the property?
No.
That agreement comes into being after filing of
Section
the.
8 only requires me to have a legitimate claim. That's all it requires.
Given
The
notice.
execution of the sale deed came from a court order which has become final and has not been challenged. Lordship may say status quo then.
Directly to meetings, registered with
Very
Petition third party.
That's been condoned. I'm grateful.
May it please your lord. My lords, Lords, in 40, my lords, the judicial service recruitment rules in the state at page 16 always had two categories. One was, my lords, direct recruits and the other was in service. The first category of direct recruits, your lordships considered in all India judges.
Dr. Sabdi, if let us say a senior advocate's clerk says that I am having an LLB degree, so let me allow and take a judicial service exam because I am regularly associated with the senior advocate
No, my lords,
in assisting his
in
briefs and
service.
papers. It's staff.
No,
in
this
a
is
judicial establishment may have a law degree. Will his working in the establishment be equivalent to a professional?
Your lordships had never considered that question in all India judges. Now, these are categories of persons. For example, they could be registrars, there could be court officers.
As much as there could be a driver. As much as there could be a driver.
With a
as much as there could be someone else.
So, my lords, categories have been carved out. Page 17 would answer your lordship's question, my lords. Your lordship's exact question is answered at page 17. The categories that were carved out, for example, in Karnataka, my lord, this has been a practice across the board. Clause 3 at page 17, no officer or official in service shall be eligible for appointment as civil judge unless they are working in the High Court and court subordinate in the following cadres. So deputy registrars and assistant registrars, section officers, stenographers, bench officers, and these are persons who have historically taken the exams and been appointed, my lords, to the judicial service.
CG, Shrestadar.
Shrestadar. Lords, this, your lordship.
That's what we say. Then why, Dr. Sondi, your clerk will not be permitted? If a Shrestadar is permitted, then a clerk, if he gets a law degree, he should also be permitted.
Your lordships in all India judges only considered the. No, my lords, your lordships only considered in all India judges the recommendation of the Shetty Commission, whether it should be freshers or 3 years.
Dr. Singh, we would have understood your argument had not that experience of 3 years.
Yes.
As a lawyer,
please.
Been incorporated in the last order of the All India Judges case. Now see how significantly it changes the pool. It is not only a degree, but also a particular experience.
Yes.
As a lawyer, which is equivalent to law officers in respect of
I'm grateful.
Prosecutors, etc.
Now, my lords, a judgment writer who works with a High Court judge, let us say for 3 years, has a rich experience of their own. Your lordships carved out an exception.
Everyone is not Lord Ganesha.
Lords, your lord.
He is not an amanuensis.
Your lordships carved out.
A stenographer is not equivalent to an amanuensis.
Your lordships have carved out an exception. Kindly, my lords, bear with me. Your lordships have carved out an exception in the judgment, for example, for law clerks. Now, the experience of a law clerk is on the one hand, the experience of an officer in the High Court, my lord, stands in its own right.
Extend it to a Sherestadar with a law clerk.
So, therefore, now, my lords, the High Court order at P13, page 172, we challenged, my lords, the amendment. Because Maharashtra, for example, has continued to carve out separate categories. And I would request your lordships to settle this position because my lord's judgment is being interpreted differently by different states. When we challenged the amendment, my lords, in Karnataka, the learned single judge's order was that without prejudice, subject to outcome that I can only apply. No rights were created in my favor. I'm only requesting at this stage, because the cutoff date, my lords, have extended qua certain serving judicial officers by other orders that have been passed subsequently. The question would be considered, my lords, at your lordship's door or before the learned single judge. But at this stage, my lords, to shut out this entire pool who were historically always, my lords, applying and participating in these examinations, there are 6 papers. They have to write, my lords, very detailed papers. I have produced the exam material. Then they undergo a viva voce. And till your lordship's judgment, they were very much being recruited from this pool. As I pointed out, they were 2 separate feeders. So at this stage, I'm only requesting, my lords, that the learned single judge's order, and the High Court very fairly submitted before the division bench, that if my lords were to issue that direction, they will accommodate us. Finally, my lords, whether that rule...
Obviously, that every High Court will do that once we...
Yes, but here the division bench
that
state...
what will be in the interest of the quality and standard of the judicial...
Quite so, my lords, quite so. Today, if a law clerk
Permission given that interim order is an unreasoned order. Just 4 lines.
Kindly come to the order, my lords. Your lords will find it's a balance.
172.
Yes, it makes 4 conditions, my lords. And
that are the conditions of the injunction.
Yes.
But why should the injunction prima facie case made out?
That was argued.
Understand?
I understand, my lords. Those reasons are...
It's in the nature of a legislative amendment.
Yes.
To rules.
I fully...
You are actually injuncting a rule.
I'm aware, my lords. Health for millions, your lordships have said there must be a higher threshold. I'm not at all, because I cannot make good that part of the order.
Correct.
But now that I'm very respectfully submitting, your lordship's direction in All India judges, and my lords are fully aware, carved out exceptions. For example, a law clerk. And your lordships would consider that, because today, my lords, Maharashtra, may I show your lordships, after my lord's judgment, Maharashtra has continued a 2 feeder, my lords, recruitment process. If your lordships like to have a glance, there are 2 categories. If my lords come to clause 7, I'm sorry, we did not annex this with the paper book. We got it later. Clause 7, my lords. This is the 2026 advertisement. Category 1 is advocate with 3 years experience. Then, my lords, comes ministerial staff of the High Court, minimum 3 years of service with a degree in law. So each state has, my lords, understood your lordships' directions quite differently. And I can tell your lordships responsibly, the directions in All India judges really did not consider the question of in-service. They were not even heard. They have their own right, my lords, under 14 and 16 to be considered for public employment. My lords had only considered whether the fresher versus 3-year requirement, my lords, needs a change. And that underwent, my lords, in fact, a 3-fold change. 93, 2002, basis Shetty Commission report, and then back to 2025. And my lords have issued notice on clarification applications filed by other categories. At this stage, my lords, all that I am requesting is permit them to kindly apply. And then your lordships may either direct the High Court
before us.
Yes.
Various applications keep on coming. You file an application, there will clarify it, and that to this extent you may be right that we need to introduce a uniform eligibility criteria.
Please. Your lordships may be pleased to
treat this from state to state.
Yes.
For that you file MA in that case.
Would my lords like to treat this as an application, my lords? Because I went to the High Court challenging the virus of the rule.
No, that will somehow...
This is where we are joining issue with you. The rules virus is not really in question. The rule has carved out its difference with regard to, and the classification appears to be a reason.
Lords, that would be tested before the High Court. Really, because we were never heard here.
Taken out, It has to be a modification prospective.
Yes, but not a,
Relate back to a selection process.
I'm so grateful. But your lordships in the direction in All India judges never directed that other pool of in-service to be done away with, my lords. Your lordships did not direct in-service to be completely excluded.
Read it impliedly excluded.
That would be the question now, my lords. Why would
Excluded.
my lords, a court
When-
officer,
when
for
there is a
example,
mandatory direction of experience and exceptions carved out in respect of certain categories who are law officers or law clerks, then all other by
my lords,
necessity.
today registrars,
Until and unless an MA is taken out, and as the Honorable Chief Justice indicates, we clarify and make it clear that these ministerial staff, maybe a registrar and an assistant registrar, may be excluded. But look at the array of staff which is included in the Maharashtra rules. The
Karnataka was
rules.
the old rule.
And very interestingly, the discrimination that I was pointing out is taken care of in the Maharashtra rule, where even a staff in the government pleader's office is permitted.
Is permitted.
Also.
What fell
But
from
as
your
I said,
lordships,
that
I
why
see that.
your clerk will be excluded?
But my
He
lord,
has more experience in handling briefs and law reports.
I would in fact, I would welcome that.
junior lawyers.
Your lordships would welcome that diversity also to the, it's an entry
Definitely
level of.
do it, but prospectively, not in respect of this selection process.
My lords, I was,
There is no hostile discrimination here.
as far as I was concerned, my category of candidates hitherto were always considered. Your lordships never intended to exclude. I can understand my lords are now saying impliedly, but then your my lords.
It's impliedly. But you are right that maybe at a time when this order was being passed,
Yes.
it was not placed before the bench that there are other categories of persons who are feeder posts.
Quite so. And their experience in its own right is a rich experience. After all, registrars also, my lords, of course, with.
Never, but we indicate the wide array of staff.
Quite so.
Which has been from the bench clerk till the registrar, whoever has a law degree.
So, my lords, while your lordships consider that, my lords could consider.
The file application in that case, because the two honorable judges are still there, because that's a special bench.
Very well, my lords.
They come, they are with me in that spaces.
Quite so.
What kind of deliberations could
Augustine
play?
and
I will do that with one indulgence from your lordships. Lords, please permit them to apply. Their outcome will always be subject. Your lordships will see the order of the single judge.
All these complicate selection procedures.
Lords, not at all. The High Court has fairly submitted that it would have no objections. Please see the conditions, my lords. I'm sure your lordships would find favor. After all, this was an outcome of your lordship's direction.
Able to say that they have no objection when the rule is amended already. They will have to.
Please have a look at 172, my lords, the 4 conditions imposed. Your lordships may reiterate. I'm showing the.
Even High Court won't be able to entertain an application contrary to rules.
I quite see, my lords. The condition imposed here was that I will not claim equities, that it will be without prejudice.
So therefore, the issue will be that whether the rule is bad in law, liable to be struck down.
That can only be done after the High Court had recorded they have a prima facie case made out of unconstitutionality or unfair exclusion.
Or
without observing that,
or one other
to take an examination
there would be
when
one,
they do not fall with the zone of
there would be
consideration.
there would be
writing the rule.
There would be one other category in this case, which is whether at all your lordships intended by the directions in All India to exclude this category. That would not necessarily be an Article 14, my lords, or a legislative.
Correct. That is why we are saying it can only come, you're right,
from your lordships.
Spring, when you take out a clarification application and the order is.
Would my lords like to treat this petition as an MA, my lords, and tag it with the pending clarification petitions that are before your lordships? Those are already on your lordship's file. My lords are considering a number of clarification applications. There is in fact a writ petition of one Bhumika Trust, 1110 of 2025. That is a writ petition. And there are, my lords, 2 or 3 clarification applications, which I will give the numbers to the court officer.
Because we might consider that what should be the criteria on, as we said, on pan-India basis.
Yeah.
That past, that issue we might examine if you file an application or anyone else applies to it. We will not examine the viewpoint Maharashtra, the view taken Karnataka. We will see that what should be the approach
Please.
in a uniform pattern.
So would my lords be inclined to tag this and consider it
No,
even as
no,
an?
no, no.
My lords would like me to file a separate MA. my
Some
lords.
MMA file.
May I, my lords, beseech your lordships for some protective order. This is a legitimate expectation.
We can pass
Let them kindly apply. Even the examination schedule is not announced.
See, please appreciate, today it's not the question of our judgment or High Court judgment. Today your statutory rules have been amended.
There are 15 persons, my lords.
There is an embargo created under the rules. Unless that rule is found to be unconstitutional, struck down, how will you acquire eligibility?
My lords, short of that, as I submitted, your lordships would see whether the rule meets my lord's direction in all India. There are 15 persons. I am not requesting that this be an order in rem. These who had the benefit of the order before the learned single judge may be permitted to apply. The calendar, my friend, is for the High Court is yet to be announced. Exams have not yet been scheduled. I will apply and thereafter be in your lordship's hands in the MA, my lords.
No, we will not be able to pass this order in this proceeding. We will see that if so MA comes, what can be done.
Your lordships may kindly give me that liberty, my lords, then too.
Yes, we are not inclined to implement especially the different. Our liberty is granted to the petitioners or any other aggrieved person to do an appropriate application in the pending proceedings where eligibility for recruitment to judicial services, where the judgment in relation to the eligibility conditions for recruitment to judicial services was passed.
The last date may be kept open, my lord. That was a direction my lords issued in the other matters to keep the last date open. That would inure to the benefit of all. It's not just me.
You're not showing anything yet.
I'll come back to you. Grateful.
Online discount.
May please, my lords. I beg to appear for the petitioners in.
My lords, I'm being led by Senior Counsel Mr. J. Sabla. He's appearing for VC.
The Salva is it.
Just
Sir, please unmute. Sir, please other device disconnect. Lordship, am I audible? Okay, sir. Item 41, multiple FIRs have been filed against us, in various states in respect of the same set of transactions.
Pavla, we are not entertaining any of these petitions. We are.
May I just explain? These offences are covered under the Banning Unregulated Deposit Scheme Act. Your lordship is examining whether it is central agency, CBI, who will investigate. That issue is pending before my lords in a connected writ petition where my lords have already issued notice.
No,
that is what my friend has the order. That is criminal rate 47 of 2026.
Victims of the crime, not at your instance.
Under the Act, there is an overriding provision under the Banning Unregulated Deposit Scheme Act. If your lordship may have a look at the Act, my colleague will show the Act. There is an overriding provision.
Those offences under the Special Act are in addition to the code and BNS offences. So if investigation is done for the BNS offence, there is no lack of.
No, your lordship is right. Here also, if your lordship will see the FIRs include provisions of BUDS, BUDS, that is the Banning Unregulated Deposit Scheme.
It will be filed under the BNS offences.
Charge sheet will be filed. Kindly just see the provision of the Act, it's a central Act. And your lordship is examining whether the CBI in such cases.
We accept your contention that the state police ought not to have investigated the BUDS Act offences.
Yes.
But we are not inclined to do a dovetailing of the FIR. If FIR has BNS offences and the state police has jurisdiction, very good. If a police report is filed under BUDS, to that extent it will be invalid, but it would be valid in respect of the other offences. Why
If
should
you lordship will see the provisions of the Buds Act, there is an overriding provision. And
Yes,
the
overriding provision is
investigation.
it relates to the Buds offences. It does not
There are
override.
Buds, the FIR also invokes Buds provision. If I may just show the FIR, Manoj, at least 2 out of 18 FIRs also include Buds provision, that is a depository act. And Manoj, for the same set of transactions.
Go to the High Court and ask for stay of those Bud.
Manoj, there are 10 states. 10 states where FIRs have been filed, and same issue my lords are examining. Identical issue in writ petition number 47 of 26. Where your lordships have issued notice.
You are not inclined.
May I just request my colleague to hand over the order where my lords are examining the same issue?
Yes,
And
that will be examined in due course. Don't worry.
Manoj, as far as the petition is concerned, this will lead to multiplicity, and that is why the act was promulgated.
That grievance from the victim's end will be well taken, not from the convenience of the accused you are talking.
Would your lordship just consider, my lords, the provisions of the act for a moment, my lords? If your lordship will just see the provision, section 34, which has an overriding effect. And section 34 clearly says that it is the central.
Reiterate our contention about the overriding provision. It overrides to the extent of Bud offences, but
Yes,
not
so-
the BNS IPC offences.
Your lordship is right. If your lordship will just see the list of FIRs, which is annexed at P1. Your lordship has the act, my lords? What's that? Kindly just see the provision, my lords. It isn't just to, my lords. I'm sorry, my lords, I'm not able to, your lordship's question, I'm not able to understand.
Mr. Saab, sir, I've clearly indicated to you the overriding provisions do not take over the jurisdiction of the state police to investigate IPC offences.
Your lordship is right, but kindly see the FIR filed in this case, my lords. The list is attached at annexed at P1.
At this stage, it may arise only if a police report is filed of offences along with Buds Act. To that extent, the Buds Act offences may be excluded from the case. That's all. And with regard to multiplicity of FIRs, we are not impressed with regard to the inconvenience of the accused. That is something we may look into when only victims are inconvenienced.
So same issue also came up before my lords in the matter of Olega Satyam. And if your lordship will just see the decision of Olega Satyam, where this court has authoritatively pronounced that repeated production warrants are not acceptable.
Production warrant is a different thing.
No, in respect of FIRs,
Salve, if production warrants are issued without application of mind or by the appropriate court having jurisdiction to do so, lacking jurisdiction to do so, the jurisdictional judges and the High Court can look into them. That's no reason for clubbing FIRs.
Your lordship is right. Olega Satyam is a case where
there is a clear difference between multiple offences of similar nature and FIRs emanating from one cause of action. One cause of action is one, let us say, like a defamation case. Yes. Or a publication which is violative of 295A, 153, 10 FIRs throughout the country. We would be inclined to police them. But if a modus operandi gives rise to repeated acts of cheating individuals throughout the country, each act of cheating and deprivation is an independent offense of similar nature.
Yes.
There we will not apply this parameter and pull it all the FIRs.
Would the lordship only see page 20 for a moment?
Agency feels collection of evidence.
Page 20 for a moment, which is annexed P1, the list of FIRs and the provisions which are invoked.
It is not within the ambit of an accused to select his investigating agency. It's not within the ambit of the accused to select the convenient forum of adjudication or investigation.
May I just show me notes and then I leave it at that. If your lordship will just see page 20 for a moment of the writ petition, where the list is attached of the FIR along with the provisions which have been attracted. And if my lords were to see items 14, 17, 18, etc., clearly provisions of Birds Act also have been invoked.
Samla, we have seen section 30, that it doesn't confer any right on you to.
My lords, if the offence pertains to deposit and it is registered in several states, then and it is of high magnitude, then it would be transferred to CBI and there will be one central investigating agency that will avoid unnecessary different findings, that will streamline the investigation. Otherwise, kindly see today in 10 different states, same set of transactions.
Pray for a specific investigating agency does not lie in the mouth of an accused.
Unless the Birds Act was regulated, my lords. Your lordship were right, but the Birds Act, and that has been subject matter of interpretation before my lords in a similar matter. Not similar matter, the lordship may just tag it with that. It is coming up tomorrow in the list, as per the computer list. Writ petition number 47 of 26. Where the lordship has issued notice. Same issue, my lords issued notice in criminal writ 47 of 26, my lords. I am not asking for any interim stay at this moment or any interim bail. I am only asking the issue to be examined.
No, point is not that. Point is very simple, that you are basically relying upon section 30. You have seen section 30, that does not clothe you with a right to seek referring the matters to CBI, number one. Number two, if the victims come, one of the state comes, CBI comes, we will examine it in that state.
But 34 has an overriding effect.
Every FIR is also alleging an offence other than this banking deposit. So there is an element of cheating.
I may only say that when there are multiple FIRs in several states, whether there should be one agency is an issue your lordship is examining. And that matter is coming up shortly. Your lordship may simply tag the matter. I am not even asking for interim stay or interim bail. That is writ petition 47 of 26. The orders, my colleague has the orders. The exact issue whether central CBI should examine when FIR having several offences in various states, but the underlying transaction is same. I was only in bill discounting facility, invoice discounting. For the purpose of invoice discounting, I borrowed money.
Your underlying transaction is not the same. They are similar.
They are similar. They are not identical. Your lordship is right. I stand corrected.
If you commit 10 dacoities, they do not become one offence.
No, my lord, your lord. But these are considering the magnitude of financial dealings. The act has been promulgated, and my lords are examining the provision of the act. I am only requesting that this may be.
Please, you have given the list of the FIRs.
Yes, my lord.
A poor person sitting in Telangana, sitting in Karnataka,
correct,
Maharashtra, why he should come all the way to pursue his complaint? Suppose the matters are transferred to Delhi.
No, my lord, as per the act banning unregulated deposit scheme act, it has to be transferred to CBI because there are multi-level FIRs filed.
Upon 30, section 30.
And my lords, under Olega Satyam, my lords have said that if you are not transferring, then at least within the state, transfer it to one place. Within the state, so my lords, in Telangana also, it would be required to be transferred to one state, my lord. That is what your lordship said in Olega Satyam. Your lordship would consider from that perspective, my lords.
Oh, thank you very much. Thank you. We will not entertain.
Lordship.
No case to entertain the petition is made out. And or contesting the investigation to CBI in terms of section 30 of the banking of unregulated, banning of unregulated deposit scheme act 2019. From at the instance of the petitioner is made out. It may be noticed that the petitioner is the managing director of National Capital Protection Force Private Limited. The said company commenced an invoice discounting business from 2020 under the name of Falcon Invoice Discounting, to which investments were invited from the public via an online platform. The investors were offered returns based on the discounting of trade receivable stock invoices. The allegation against the petitioner are, it seems that, that also the allegations against the petitioner are that the aforesaid platform from operating across multiple states from a function as an unregulated deposit scheme that collected money from the public without adhering to applicable regulatory framework. There are allegations of duping the innocent investors, besides cheating, etc. Next paragraph. We have heard one counsel for the petitioner with reference to the claim under section 30 of the Works Act. In our counsel opinion, this Act does not clothe an accused who's with an unforeseeable right to seek transfer of the FIRs for investigation to CBI. Such a recourse, though, can be permitted to be availed by the victims of the crime and or any other prescribed agents.
Other offences are involved. Other
Of other offences under the PNS or other penal laws being involved, the matter cannot be said to be a restriction within the framework of section 30 onwards.
Right, please, my lord. The High Court records a concession by me in the impugned order that I'll make a representation. Now here, the Gangsters Act stood quashed and the attachment takes place after it is quashed. There is no occasion for me to make a representation. Therefore, I have said so, my lord, that I didn't make this representation. It will not lie. Please see the date, my lords. 4/9/25 is the Gangster Act proceedings which are quashed at page 466. The trial court drops the proceedings at 485 on 8/9 and on 17th of February 26. Again, there is an attachment when the proceedings have been quashed. Qua me. Please see this, my lords. There is no other case. This was all quashed. The base FIR quashed and the gangsters quashed. Yet, my lord, this is an abuse of process, my lord. With great respect, your lordship.
Issue notice firstly.
Lords, can I have status quo? There are some products. This is a farmland, my lords. They have some crop standing which is there.
We can't pass an ex parte order.
All right, my lords. Obliged.
45 is a regular bail. In excess of 3 months is the time that I've spent. My lords, about 100. Charge sheet has been filed, my lords, in the meantime. About 123 witnesses.
Was only arrested on
Last person, everybody else.
We have issued notice and listed on 3rd of June.
Very good. Lordships will tag it with that.
This matter.
Grateful, very deeply obliged.
File reply.
Lordships have issued notice, my lords.
I issued notice.
We'll file.
Asking them to file reply by Friday.
Very
and on 3rd June.
Grateful, my lords. Grateful.
Right, please, my lords.
No, tag नहीं करना. अलग every matter is separate one. वो दोनों.
Wait, please, my lords. My lords, the challenge here is only limited to Direction 20D of order dated 9 February, passed by the Justice Dhulia Committee. My lords, the problem is, my lord, Direction 20D directs the creation of a separate list, that is list R, which is ultimately leading to a vote getting transferred to two persons ultimately. My lords, one for the women candidate who is in list R, and once she is eliminated, then the vote gets transferred to the other persons who are getting elected on the strength of the same vote. So, my lords, that's the logical discrepancy which we are seeking a clarification to. My lords.
See, the unnecessarily people are. How are you concerned about the?
My lords, I have contested the election. My lord, I completely support the reservation. My lord, I just want to raise this particular anomaly which has been created by the direction, because this is disturbing quota calculations also.
You go there and file an appeal, we have created.
My lords, we have already made a representation before the committee because, and
No case to entertain this petition is made out. The petition-
my lords may direct expeditious that our representation be considered.
So it is pending before the committee. We request of the pending petition to be considered the evaluation.
My lords, may I seek a stay of the counting process? My lords, may I seek a stay of the counting process till the representation is decided, my lords?
No, nothing.
Obliged, my lords.
Item 47.
In item 47, my lords, the elections are sought to be conducted by ballot papers now. Now, my lords, your lordship's own judgment, my lords, where EVMs has to be the norm, my lords, that is to be followed, and accordingly the rules have been, my lords, amended. The rules clearly provide.
Now election is tomorrow, there is no time left. What can be done?
No, my lords, but kindly see when the notification was made out, immediately, my lords, the petitions have been filed. The High Court wrongly records that it has been filed on the 18th, my lords.
No, bad, now election is tomorrow. These arrangements can't be.
No, my lords, if the notification is seen, my lords, the notification indicates, may I just indicate the notification, my lords? The elections are to take place, my lords. Would my lords kindly see? 95, my lords, is the schedule of the election, my lords. Page 95. This is 13th of May, my lords, 2026. Over the page 96, my lords, item number I. 1st of June is the last date available, my lords, by which the entire election process has to conclude, my lords. Therefore, my lords, there is still that window available, my lords.
The elections were being held, you knew everything, you are going to the High Court on the last date.
No, my lords, I don't go on the last date, my lords. Kindly see my petition which has been filed, my lords.
Filed on 18th and 19th.
No, my lords, kindly see page 99 for a moment, my lords. My filing date, my lords. It is on the 15th, my lords, it has been filed, my lords. And my petition, which is at 102, is also indicating it is filed on the 15th.
15th, only 10 days before you go to the court and you expect everything.
No, my lords, this notification comes out on the 13th, my lords. I'm sorry, my lords. The notification is the 13th.
To do with these arrangements. You knew the elections are being held. Everything was known to you.
No, my lords, the notification and my lords, P6, which comes out only on the 13th, my lords. Kindly see page 97. For the first time, the respondents, my lords, take a stand that the entire election will happen through a ballot paper, which is at page 97. This only comes out on the 13th and 14th, my lords. And 15th, immediately the petition has been filed, my lords. So, my lords, there has been no delay on our end. My lords, going further, my lords, the election commission, my lords, have filed 2 affidavits. And, my lords, the election commission took a specific stand that, my lords, the machines are available and that we will immediately provide them. The second affidavit indicated, my lords, they are waiting on the border, my lords. Whenever the state says, immediately it will be provided. Even the training facility will be provided. So where was the question, my lords? The entire blame game was.
That stage has gone.
My lords, election commission was served with an advance notice, my lords, they are here. The affidavit was filed and election commission categorically said that all arrangements will be made from their end, my lords. The allegation was that we have not been provided with the EVM machines. Now, my lords, if the election commission says all that is available, and my lords, your lordship's own judgment.
There was no necessity for you to wait for the publication of election schedule being issued. You knew that elections are due, elections are to be held.
Yes, my lords.
It's not that first time litigation generated. You had several rounds of litigations earlier. You could always request the High Court that please tell them to make all necessary arrangements.
But, my lords, unless page 99, my lords, that communication comes out, my lords, it was presumed that they would be doing it through the EVM process, my lords. It is only in the circular which comes out on page 97, my lords. For the first time on the 13th and the 14th, my lords, they come out that it will be ballot paper, my lords. And very next day, my lords, page 99, on the 15th, we file it, my lords. 13, 14, and 15, my lords. Kindly see, my lords. There is no delay, not even a day's delay to file it, my lords. Plus now,
is for
yes, my lords. elections are scheduled for tomorrow, Milods, but the process can be completed by the first, Milods. There is still a window, Milods. Entire process can be carried out in the EVM manner, Milods. Your Lordship's own judgment, your Lordships may kindly see the judgment also we have next year, the Association of Democratic Reforms, Milods, where this court has taken into consideration how in India, from physical ballot papers, Milods, we have moved on to the EVMs.
Until and unless.
Yes, Milods.
Presentation of People's Act and the rules.
Yes.
Are amended to delete ballot paper voting. The decision of the Election Commission to do a ballot paper voting will be within the jurisdictional domain of the Election Commission.
It can be a jurisdictional domain,
Yes.
but Milods, that decision has to be guided by some reasons, Milods.
We are not going to second guess that.
Yes, Milods. Unless Milods, some exigencies are shown by the state, Milods.
That we are also conscious in ADR.
Yes,
it has been described as a regressive step.
That's right, Milods.
Correct.
Yes, Milods. I'm so obliged.
But it's not a jurisdictional question. And if it is not a jurisdictional question with an election process going on, we will not interdict it.
Milods, what has happened is previously also your Lordships are aware that petition which came up before this honorable court against the 24, this is the Seema Sharma case, Milods, which is also pending before this court. That order is at page 80, Milods. There your Lordships had appointed a high-powered committee to look into the factual aspects, Milods. There were a lot of allegations there as well.
Mr. Joshi, that's why we are pointing out that
Yes.
it's not the first time that this litigation is.
Your Lordships are very much conscious how it has been happening.
Several round, you could at any point of time, you could raise this issue.
Yes, my lord.
Appropriate directions, timely directions could be issued at that time.
But Milods, if Milods,
You people never raised that issue.
no, Milods, page 95 is the election schedule.
What you expect the authorities to do it in a couple of hours?
Milods, if the machines are waiting on the border, Milods, what the ECI is standing, Milods, the standard council is here. If the EVMs are available, Milods, and it can be provided, Milods, all the functionality support which is required for.
ECI does not conduct municipal elections.
No, Milods, absolutely. Milods. I'm not even saying that.
So the person who is conducting the municipal election is not before us.
Milods, it is the state, Milods. It is the state.
It does not conduct the election.
Milods, the state election commission. Therefore, the state election commission will have to take a call, Milods.
So that authority is not before us.
Milods, we'll serve them immediately. Your Lordship may have it.
Why should we?
Yes, Milods.
We would have gone into that.
Yes.
If you had pointed a jurisdictional error.
Milods,
but in the absence of a jurisdictional error.
Yes, Milods.
An unwise choice
Yes.
is not something which will persuade us to destabilize an election.
So, my lord, therefore, your lordships may see page 97 is the decision that they take. Would my lords kindly see whether that decision, is there any application of mind at page 97 when they decide?
We cannot
Now, my lords, kindly see what has happened.
Whether it is without application of mind, whether unwise, etc.
Yes, my lords.
It is the ultimate master of elections is the election commission, the state election commission.
Yes, my lords.
If the state election commission did not have the power,
yes, my lords,
to go into a ballot based paper ballot
yes,
election, we would have injuncted.
Then your lordship therefore may see the act and the rule. Would my lords kindly see the rules which have been amended in the state of Punjab, my lords? Kindly see the rules, my lords.
48A.
My lords, 48A, but also with that, my lords, may I just pass on the act and the...
That said that 48A will be in preference to Rule 52 and other rules, we would have agreed with you. They are together.
Now, my lords, in the rules, my lords, if the rules are saying section 2N is on the voting machine, my lords, what will be? And that has been amended.
That only shows that if the election commission chooses to go for EVM voting machine, it is within its powers. But the ballot paper election has not been deleted from the scheme of the Municipal Act or the municipal rules. So it is open to the election commission to take a choice between ballot paper or EVM. We are also in agreement with you. The election commission is required to take into consideration the observations in the ADR judgment.
Yes, Bruce.
It is a regressive step to go back.
That's right, my lords.
Correct?
That's right, my lords.
On the point of a regression or an unwise step,
Yes, sir.
after the election process has commenced, it would be extremely inadvisable to injunct or to regulate that election process. We can make observations for future elections. That is all.
Therefore, my lords, 48, your lordships may see, 48A has been added, my lords. 48 would, my lords, see the scheme of the rules which has been brought out, my lords.
Space 7, you have seen that.
Yes, my lords. And therefore, my lords, if having brought in 48A, my lords, in view of the judgment of your lordships, my lords, in view of the judgment and the amendment of the rules, my lords, therefore the state, if there is no basis for it, has to follow the EVM process, my lords. And it cannot go back to the ballot papers, my lords. Why, my lords? Because your lordships have seen there have been serious instances where violences have been taking place, my lords. Booth capturing is being taken place, my lords. How do we stop this, my lords, in the current scenario? Your lordships have already seen the Bengal elections, my lords.
Law and order machinery would fail.
Yes.
Then even EVM is not going to help.
No, my lords. I bow down. I bow down. I bow down on that, my lords, that law and order is a completely separate issue. But, my lords,
And if they fail, one should take very serious notice of it. That's
yes, my lords, but the booth capturing fact, my lords, which your lordships have seen over the years, how and in what manner it has happened, my lords.
Booth capturing takes place, that
Yes.
amounts to failure of law and order.
Yes, my lords.
So that-
Yes, my lords.
That's what we are saying, that
Yes,
we will have to ensure it.
Absolutely, my lords. That is both a
Elections, are you appearing, madam, for this state?
No, my lord. I'm in the next matter.
Next one.
Next.
For the election. At least for future elections now, you adhere to your amended rule.
India, my lord. ECI. I appear for ECI.
Acha, India. Accidentally you charge from them.
How much?
Is there any?
No, my lord. The only charge that the State Election Commission has to pay is for the transportation that is involved, my lord. Nothing else.
Otherwise, don't charge them.
Nothing else. Election Commission had framed a policy in 2022 to lend the EVMs to state election commissions, my lord. Accordingly, whenever the requests are made 6 months in advance, we lend it. Here in this case, my lord, the letters were sent only as late as in January, but still the preparations.
So I was only reflecting because for the last year Bar Association election.
Yes,
the machines were called and there were heavy charges which were paid.
Right. But with the state election commissions, my lord, election commission doesn't charge anything. As on date, my lord, the EVMs are there in the respective districts, my lord. They have already reached, and my instructions are, my lord, that ECI would need at least 3 days for the first level checks and the training that is required to be given.
3 days, then tomorrow is the election. Then nothing can be done. Sorry, it's too late to interfere.
My lords, may I just suggest that then, my lords, in the process, my lords, in the process, would my lords consider to appoint some observer to take care of the election which is going on, my lords? Some senior IPS officer outside the state, my lords.
So see, that was not the prayer before the High Court.
No, my lords, your lordships can always mold the relief to ensure, my lords, that the elections happen.
Why are we going to presume an unfairness in an election?
No, my lords, I'm not presuming unfairness, my lords, but the lordships will have to ensure.
If you are not, then there is no question of an observer.
And the system
An observer is a very serious intervention. And we are the last persons to do it in an election process.
Well, as my learned friend indicates, there is an amendment to section 64 of the Punjab Election Act as well, Mullahs. Under the amendment, what your lordships were indicating to me, Mullahs, under the act which has been amended, Mullahs, there also, Mullahs, EVM has been accepted as the norm, Mullahs.
Absolutely right. They are simultaneous
Yes,
processes.
Yes, Mullahs.
But they are not exclusionary processes.
Please, Mullahs.
Thank you. Thank you. Item 19.
Obliged.
Please, my lord. My lord, this is the Indian Coast Guard retirement age matter.
Petitioners, my lords. I'm appearing for the petitioners in the matter.
My lord,
My lords had issued notice, and my lords, wide order dated 27th of February 26 had asked us to prepare an expert committee report. We have filed it on 10th of April 2026, my lords.
But an expert committee has been constituted.
Yes, constituted report has been filed with my lords. 10th of April.
My lord, I want
I
to
can
say
take my
something-
lords through the expert committee report.
My lord, I wanted to say something on that very report. For the fourth time, my lord, after the Honorable High Court, they've got an opportunity to file this report. And this report does not show anything.
Yes.
This report does not show anything, my lord, to say that we are similar to the Indian Navy. My lord, it's
I
very-
would
my
want
lord,
to
I'm
place
saying
in
for
detail.
reason. My lord, several officers are retiring. They've been fighting since 2019.
No, but if there, we can always.
My lord, I'll
My
just
lord's on
take
the-
2 minutes to explain. My lord, we've also filed an application because several officers who are retiring, my lord, they had succeeded before the Honorable High Court. 68-page detailed judgment, my lord, considering all the reasons that they are giving now. They have not been able to explain in the report that how we are similar to the Indian Navy, which we are not when it comes to pay, perk, allowances, all the maritime security pension, disability pension, OPS, my lord, then they
My
say
lords,
we are not
my
similar.
lords,
Please
I
don't
have to
interrupt. This
place.
is very important for the officers.
My lords,
They
I
made wrong
understand that.
statements last time, my lord. We have no submarines. We have no fighter jets, my lord. All these statements were made in the court on the last occasion when notice was issued. We took instructions, my lord. Coast Guard is absolutely different. It's a patrolling force, my lord, managing surveillance, managing oil spill, pollution control, my lord, very different charter of duties from the Navy. When it comes to pays and perks of the Navy and the defense forces, they say we are different. We are different from the Navy. They are not giving us same parity as the BSF, as the ITBP, as the CRPF, where now there is an equal age of retirement. So who are we, my lords? Who are we? We are not the Navy because we can't get those pay and perks. We are not CAPFs who have got this advantage after another detailed judgment of the Honorable High Court. The Madras High Court said that we have to be considered as a paramilitary force.
Decide this issue in 5-10 minutes.
My lord, I
lords,
do see
the-
that. My lord, what
The
I will
Coast
then
Guard
request,
Act
my lord,
itself says that
my
it is
lord, I
a
will-
armed
my lord,
forces.
I will argue it
I-
out. Very general submissions
It
have
has
been
to
made
be
before the
argued.
Honorable
That's what
Court.
I'm submitting.
My
I
lord,
can
I
place
just
the
want to say
expert
one
committee
thing.
report. I can place the expert committee report. All these issues have
My
been
lord,
dealt with, my
expert
lords.
committee report says after 50, nobody is required to go to sea. It will show from their report. And this is what they've used for issuance of notice that sea-going officers are affected.
That expert committee report in terms of our order dated 27th February 2026 has been placed on record. Then say, post the matter for hearing on solicited NMD. As regard to the application for vacation of ad interim stay, moved by the
Intervening.
from Indian Coast Guard officers, it is clarified that the retirement, if any, during the intervening period shall be subject to outcome of this process.
Very grateful.
Grateful.
Very grateful.
It's also incomplete, so you make sure that the
We'll do that, my lords. We'll also file a rejoinder affidavit, my lords, to the counter affidavit that they have filed.
My lord, may I request for a date in June if not inconvenient to my lords?
not be possible.
Lord, only seeing the anxiety of the officers, I was making the.
No, nothing very much. Well, then, let's hope till July or.
Please, my lord. Very great.
We'll file a rejoinder affidavit, my lords.
Yes.
Grateful.
Item 25 is the Aravali matter. Is there any Union of India suggestion?
My lords, the CEC has given their names, my lords, and Union has filed an affidavit. Your lordships had directed us to give opinions on terms of reference. Your lordships order, first order is clear, my lords. We don't want to add to the terms of reference, so the committee has.
Terms of reference can also be elaborated.
Please, my lords.
We can make them more expensive, more wide.
Please, my lords.
Wider if so required.
Yes, madam.
There should not be any difficulty. But we are mainly concerned about some
Members.
members,
CEC has
domain experts.
names, my lords. CEC
Some of the suggestions have come from the learned micas.
Yes, madam.
If you want to verify, you can verify, or better, because we should not delay the constitution of the committee.
Please, my lords. No, we have, my lords. In fact, we agree with the names that CEC has given, if your lordships may consider that, my lords. And the amicus's name, my lords. Four names are.
CEC has also given names.
So, my lords, Mr. Parmeshwar, the learned amicus has given names in which four names are common. Serial number 5, 6, 8, and 9. That your lordships may consider, my lords, because CEC and amicus have given these common names.
Common names.
Yes,
My lords, it's at page 18 of my submission. I have actually listed multidisciplinary, what is the role of each of the persons I have suggested to the Honorable Court? They are multidisciplinary, from meteorology to botany to air water experts to forest governance people. 4 people in my list are common to the list which the union has presented.
So if we constitute, suppose first of all, that what should be the composition, that how many members? A very huge committee sometime becomes.
No, my lords, also,
They may,
my lords,
they co-opt any experts that they want to for specific reasons or specific purposes.
They can always associate.
Yes, my lords. Let the committee be
And
only
also,
for
my lords,
5 members,
if
5 members.
on page 16,
And in 5, the 4 names in any case are common.
Please, my lords.
We can think of one more member.
My lords, that I will recommend your lordship
lords.
Director General of ICFRE, that is Indian Council of Forestry Research and Education. Let them be the chairperson, so institutional. Yes, my lords.
I think that's a fair suggestion.
So she can be, current incumbent is a woman, but any chairperson, my lords, if the work continues, then the incumbent of that chair can be the chairperson.
my lords, at para 14 of my submission, I have suggested several institutions which should be member of this expert committee, because they are the ones who are going to provide the data, the underlying data to the committee. So paragraph 14 at page 16 of my submission, I have listed some 6 institutions which should necessarily be part of this expert committee.
My lords, they are also good suggestions. They can be, my lords, co-opted. So these are institutional expertise. Survey General of India, Forest Survey of India, Mines Bureau, Indian Mines Bureau. My lords, they can be.
And the leading laboratories from across the country.
Domain expert for one particular purpose.
Yes.
Their field of specialization. So they are engaged. They need to be associated.
Correct.
For the purpose of utilizing their expertise. Then another expert for their purpose.
Correct.
So this kind of maybe a very varied team of experts will have to be.
Please, Your Lordship. Please, Your Lordship.
So,
So therefore, a committee of experts, say 5 or 6 experts, and then institutional members in that committee is what I sort of submit to the Honorable Court. Because the institutional members will provide the necessary bandwidth in terms of the data. Forest Survey will provide, the various inputs. The Geological Survey of India will provide its inputs. Same with Indian Bureau of Mines, if they have inputs on this very important issue. And there are 3 laboratories, one at Jamshedpur, Bhubaneswar, and Hyderabad, CSIR. This is government laboratories, which should be made party, and experts from Indian Institute of Technology, who are Dhanbad, who are mining, engineering, and earth sciences experts. So my suggestion to the Honorable Court is that para 14 may kindly be considered.
Lord, I wanted to say something.
Yes, Mr.
There was a report by the Forest Survey of India given in September 25 on the area of the Aravalis, which had been suppressed from this court in the previous proceedings, in the proceedings which culminated in that order. Now, Lord, the Director General of the Forest Survey of India, who was at that time associated with the preparation of this report, which was suppressed, it was precisely on the Aravalis itself. He should definitely be in this committee. He is one person, my lord, who understands this issue fully, who has already participated in an earlier exercise. He must definitely be in this committee.
my lords, I take objection to this submission that there was suppression. The learned amicus was there. I was assisting, my lords. All the reports were there. There was no question of any suppression. And my respect to submission is, your lordships may look at the individual names where there is unanimity between CEC and the learned amicus. 4 names are unanimous. Your lordships may take that, my lords. And let the chairperson be ICFRE. Others can be co-opted. On individual names, my lordships may consider only taking the CEC recommendations and the learned amicus's recommendations.
Your lordships, the interveners have also given some names.
And they are not represented at the moment, Milord. The Indian Bureau of Mines are experts which we have suggested from the United Federation of Mineral Producers.
Stakeholder for preservation of whatever.
No, the United Federation
I don't understand how that is.
Producers.
I don't understand. Mining Producer Association is the stakeholder for preservation of whatever.
A conflict of interest.
God.
stakeholders
People are
are going to be affected by this, this entire.
Let it be affected. Who bothers about
They
the
should be heard as well, my lord. This is my.
How many? Everybody will say I'm affected. If there will be millions of villagers who will say, I have been given the land on this hill. I am also likely to be affected because he can't be allowed to have any agricultural activities or non-forestry activities. Then everybody will be affected.
What I am
affected means that once the expert committee is constituted, they might invite suggestions from everyone. And there you can also.
That's saying something else, brother. I'm saying that the Indian Bureau of Mines former Controller General, they are those important scientific experts on this issue. And they may be kindly considered. That's my humble submission, brother.
Yes, yes.
Yes.
But I had only one suggestion in my note, which I had given. But one of the fundamental flaws of the previous exercise was the public was not heard. I am not saying everybody must be given an oral hearing, but your lordships will definitely make it a part of the order that whatever committee your lordships are now fine will devise an appropriate mechanism to invite suggestions from all stakeholders. That is so. Because the previous exercise did not do that. Nobody was consulted. So your lordships.
And that's why we just pointed out immediately, because that they will have to hear everyone. There will be different stakeholders. There sometimes very good suggestions come from even from a common man, ordinary person can give very good suggestions. Those all should be respected, considered.
Your lordships will inbuild that into the order itself so that that mandate is clear.
Fair, my lords. Your lordships, even the interveners have given some suggestions, your lordships, as per your lordships' last order, had asked us also to, some of the names are common, your lordships, that's fortunate for us, that some of the names which have been suggested by the amicus and the other CEC, like for instance, Udayveer Singh is somebody across the board. He had done a lot of work during mining and remediation in Karnataka, your lordships. And also Brij Mohan Singh Rathore is also a common name. We were suggesting, your lordships, if there are going to be...
If those common names are already there,
yes,
fine. Otherwise, there are some other names you want to suggest.
Yes,
can you please?
Yes, your lordships, we've given our suggestions, your lordships. They can... for instance, Mr. Devrajan is somebody who was a member of... Yes.
Name them in the open.
Yes.
Because otherwise,
I understand.
That somebody has been given preference. We don't.
Fair.
All of them must be outstanding experts.
Yes, we've
the only thing is that because of the composition, we cannot have a composition of 30 people, 40
No,
people. It will become
becomes very
unmanageable.
heavy, your lordships.
It becomes unmanageable.
Yes.
So committee can be ideally of 5 or maximum 7.
Right.
But they must associate other domain experts. There are
Yes,
people like somebody may be in forestry expert, somebody is a geographist, he is only on with respect to the geographical conditions.
Yes.
So his role will be to that extent. So their limited expertise role should be utilized.
Yes,
and that expertise should be.
Yes. And anyway, your lordships, I think everybody is ad idem with the fact that they should be institutional members like Forest Survey of India, Surveyor General. Our only objection was if the current serving members of these institutions are members, then the ex-member should not also be. Then there will be some
overlapping.
Yeah, that'll. Your lordships may then we'll give all our suggestions which we've given to the amicus. Let them collate the list, your lordships. Then your lordship
is collated and given to your lordships. My lord, collated list.
All
suggestions.
My lord,
all
at
names.
page 26 of
All
my
have been
submission.
collated and
given to your lordships.
Collect. We will
Your lordships will take a call, Milots. Your lordships will take a call on the members. Milots, I just one more suggestion, if your lordship so permits me. Your lordships indicated that wider term of reference, Milots. Page 21 onwards of my note, Milots, I have attempted to keep the terms of reference and the principle as wide as possible, Milots.
Yes, sir.
That I've indicated in my note. Your lordships will just
take widest possible reference.
And your lordships will give some guiding principles.
So that the expert committee's hands are not tied to look into and examine anything at submitted.
Your lordships, we've also given suggested terms of reference also. Your lordships in your order, in the first order, had given 10 names. Some suggestions.
Was only a tentative opinion,
But your lordships
which whatever we could gather after reading the material. So
we've also added to that.
My lords, the last point in your lordship's order says all ancillary issues that may arise.
Yes,
so
that-
that also has to be kept open because that's an expert
Yes,
committee.
that left open.
My lords,
my
lords.
We have filed not an individual IA. Now, my situation is slightly different. Your lordships, when your lordships passed the order, said needless to say that an ongoing legal mining operation shall not be prohibited or stopped.
Everything we have
The
said.
legal operation which is going on.
That legal word itself has become little bit dicey there.
That's all right.
So
But
that
if
is
I have
the
all the permissions, I'm cleared by the High Court also earlier. So I want your lordships to just examine it.
Right now, you need to have some patience, that's all. Because by the time, let the experts examine it. We are not against anyone as such. We don't want to, we don't have any.
Whatever your lordships
We
say.
don't want to say that somebody has really actually done like this one. That let the committee, because we don't want to prejudge the issue.
My lords, my lord's permission, in IA 18034/2026, we had filed 3 names, man. These are experts who worked on the Aravali, have done research, my lord. If not on the committee, they might at least be invited to give some suggestions.
Please go to Micah's name.
It's filed on the same.
Even
Grateful, my lords.
Some of the new names, my learned amicus may forward those names.
Yeah.
also.
I'll do that.
Yes,
Do that.
your lordships,
I'll
there
do
was
that.
one last IA, which I think the amicus is.
I'll do
Your lordships you can add that also.
We'll do that. We'll do that.
You can give to him and.
We've given it, your lordships.
And my lords,
On-
all
on
other
sil-
experts will
on
be
silicosis.
consulted, that can be.
We will grant them full liberty and independence to engage any other expert. Also.
Please, yes, your
There may be some issues there.
Yes, sir.
Also.
So the time bound exercise, otherwise it will spill over a lot.
Give them time. Give them time. Lords.
A lot of people are suffering.
Pending before us, we'll continue to monitor it.
Grateful.
Grateful, my lords.
What happened to item 26?
Item 26.
So normally, Madam Surya appears.
I'm sorry.
Item 20.
Delhi NC, yes, yes.
I have received limited instructions on the matter, my lords. I have been informed that they have moved the file on 4th of May, my lords, to constitute the selection committee, my lords. Then in terms of section 85, my lords, they will do it within 3 months. But insofar as selection committee is concerned, I have been informed that on 4th of May, the proposal has been made, my lords.
No, moved where and ultimately it will go where?
I understand, my lords. I understand. I had put it to the department very categorically, my lords. If my lords may give me some more time, my lords, I'll be able to.
For 3 years, you'll.
2 days.
My lords.
2 days time to clearly tell us that within how many days, and it must be, if not hours, it can maximum be days that you should constitute, notify the selection committee, and then we will direct the selection committee to complete the process in a
May I
time.
only request one thing, if my lords may indicate it in the order, my lords, then it'll be
Yes.
easier for me to
The
put it to the department.
chairperson has to be a retired judge of a high court because the other 2 are technical members.
That whosoever eligible person will have to be appointed.
Because there is a judgment of this court that one person has to be a judge or a person who is eligible to be a judge. Now the other 2 are technical members, so adjudicatory functions are not being taken up for the last 1 year. The other 2 are also pro tem.
We understand, Mr. Skiva. That's why we have also
Yes.
taken up the matter out of.
And the selection committee has no role for appointment of a retired judge. That's the section.
The matter pertains to appointment of chairperson and members of the Delhi Electricity Regulatory Commission. Delhi Electric or Electricity?
Electricity.
Yeah, Delhi Electricity Regulatory.
Regulatory Commission. Learned counsel for the petitioner points out that commission is defunct from last 1 year, has no chairperson who is expected to be a former judge of the High Court has been appointed, and only technical members are.
Pro tem technical members.
And only 2 technical members are serving.
On pro tem basis appointed by this court, appointed a pro tem selection committee. And despite assurance on 18th August 25 before this.
So right, learned counsel for the government of NCT states that as per the limited instructions received so far, the proposal to constitute the selection committee has been moved on 4th May 2026.
Yes, my lords.
Section 85 is the selection committee.
Yes, that's right, my lords.
Courtroom Selection Committee under Section 85 of the Census Act 2003. We would, however, like to know that within how many days the selection committee shall be notified, so that appropriate directions can be issued to the selection committee to finalize the selection process in a time-bound manner. For this purpose, let the Landscape Council have clear instructions from the competent authority. Post this matter on 29th.
Please, my lord.
Grateful. Your Lordship may also note the section itself says, section 85, that this will not apply if the person being appointed has been a judge of the High Court. And earlier also, Your Lordship appointed pro tem one honorable judge and then the other honorable judge. And he demitted office last year.
Almost 1 year now.
Yes, 1 year now and no adjudicatory functions.
So let's see 29th.
Yes,
please,
now, sir, just I saw section 85. Probably the file might have gone to Chief Justice of the High Court for nominating a judge as chairperson of the selection committee.
Yes.
Then Chief Secretary and some other member is there.
Yes, well, that is for the members. Yes, great.
Case item 27.
In 27, before anybody says anything,
My lords,
my security is short by 460 odd crores. And my section 13, which I have succeeded in, no appeal has been filed with the entire limitation expired. Third point is, to the best of our understanding, the mediation has failed. This really needs to be heard by your lordships in July on a scheduled basis, because after your lordship's efforts, 463 crores are short. And I have succeeded in my enforcement order.
You were just keeping it pending only that mediation.
Mediation, that's right.
Mediation is done.
I'm grateful. It is. I have not got the report. I believe the report has come to your lordship. It's failed.
My lords, can I say this? My lords, I have filed because your lordship's last order of 11th May, at page 60 of my IA, was, my lords, that so far as my company, I am a public limited listed company, 60% shareholding of 350,000 shareholders. There is no doubt that the debtors, judgment debtors, have shareholding in my company. But your lordships were led to believe, I believe, because from the chart I've seen, as though they are my holding company and the whole company is nothing but an alter ego.
44%.
Based on which, your lordships, please take my IA 159692. Let me explain what has happened. My lords,
We will not take up any IA today.
No, I sought to be brought in. My lord, just give me one moment, my lord. All right, I won't ask your lordships to see anything. Let me just explain what it is. My lord's order was against me. I'm not a party in the proceedings, but against me on their say that I am nothing but an alter ego of theirs. I am a public limited listed company, 60% public shareholding, 350,000 shares. Yes, the people concerned are also shareholders. Now, what I did, my lord, was I acquired a company, unrelated transaction, acquisition for my business. That deal has to go through, and one of it is share swapping.
It's not day-to-day business.
By effect of the share swapping, the people they are interested in, their shares will go down from some 38% to 30%. But the value of the company goes up twice. That's all. Now, my lords, I'm saying that this last order, please just see your lordship's last order. Nothing more. Page, my lord, your last order of 11th May. Your lordship's last order on 11th May said, please just pass the order.
Yes, yes.
My lords, paragraph 4.
After hearing us, your lordship made that.
My lords, the last order of your lordships kindly sees paragraph 2. Meanwhile, status quo regarding swapping or the transfer of shares in respect of Moschip Technologies Limited, that is me, shall be maintained. Now, my lords, I'm not a party at all. I've explained who I am. My problem, my lord, is now today, if I don't go through the transaction, I face, my lords, a claim under the agreement of 18 crores, which I have to pay by way of penalty also. I am buying over this company. The shareholding that they are interested in will not be affected.
No, it is.
But the company cannot be stopped from doing its normal business.
Mr. Prashad is the master. He holds 44%.
Which is why I am seeking.
Mr. Prashad holds 44%. He is the master in making
39%.
44.4%.
I have stated it.
This
That
is not
was then.
day-to-day business.
It's 39%.
My lord has
Now
passed
by
the
the swapping,
in July.
the shareholding falls from 39 to 38. That is all. But the acquisition of an asset.
Please hear it in July,
Mr. Sundaram, this order will continue, we will hear the matter.
Milords, may I make,
My lords.
may I make a request? Milords, I'm for respondent number 1, Matrix. I am affected by your lordship's order. I'm a third party. I'm not a party to the, either to the original decree. I have no privity with them, etc. Now, I'll just suggest to the court, your lordships have been satisfied that over 600 crores of security has come in since your lordship's October 2025 order. Now, the orders which are passed, again, they're in my favor, but which they're impugned here. One stream arises from contempt proceedings, which was released. The other stream arises from a merger, a scheme under the Companies Act. So with this 600 crores coming in, I'm just suggesting to the court, maybe your lordships eventually might find that as far as the judgment debtor is concerned, they have to bring in some more security. But at least for a third-party company like Matrix, I'm just suggesting, you see, I have 4,000 employees. Milords, I was born after the
original sinner.
I have 6 factories. We are manufacturing the active ingredients for anti-diabetic drugs, for anti-retroviral drugs. Now, this is a going concern with 4,000 employees. Now, my suggestion, and we have...
That we have permitted you.
Everything is going on.
May I just suggest, may I suggest this? May I suggest this? There is a change now today since October. I understand your lordships had said that in the month of October, we don't want to get into, get into the detail. Now, substantial securities have been deposited both in the form of land by the judgment debtor, or he's caused it to be deposited, and a cash deposit. Now, there ought to be some change. So, I am suggesting, at least as far as respondent number 1 is concerned, Milords, let the proceedings end. Then whatever your lordship has to do qua the judgment debtor is one thing. Because otherwise, it's here you have, your lordships, I'm just suggesting, please balance the overall equities from our perspective.
If you are available during this partial working days, we can list during those days. Otherwise, in the opening.
Yes. We will do that.
Because I'll explain why.
Yes, your lordship may put it on a partial working day.
Lordships have recorded in the order that the decree is substantially not secured.
No,
Cash deposit and by a property deposit.
600.
If that is so, for purposes of execution,
Property
it is
highly
secured.
disputed with the
Put my
airport.
hand up. To keep the others going on.
600
Can go on, Milord.
Please have a shortcut. Please hear it in July. Please hear it in July. The security is 400 crores of disputed land, 250 crores in cash. It's all highly disputed. There's no solvent security.
But I appeal for the. But I appeal for the judgment debtor. But it's not 600 crores. It's substantial extent of the claim of the petitioner is secured. And Manoj, that amount is 845 crores, Manoj.
Just like that.
If all of you are available, we can hear this matter.
Don't work out. Please have it first.
Manoj, your lordship may put it in the vacation.
Yes, July.
Can't be dependent on consent of council. Please put it in the vacation. Whoever is here will argue with Manoj. Our clients.
Your lordships recollect that Mr. Subramaniam had said that they will be filing an appeal against the execution. Mr. Subramaniam had said
Yes.
so. They still haven't
We are
filed.
doing so. No, we are doing so, but
for
Manoj,
3
let me
months.
correct.
Is your interest?
Manoj, let me correct the
July,
amount.
we'll argue it out.
Because my whole.
Please appreciate. In vacations, we can only list the matter when both sides agree. If you both agreeable, from 15th June week, we are already.
They won't agree on. They have strangled us.
They'll never agree. We are actually not here.
Others are available.
But we are actually not here. Your lordship, I did not know your lordship was sitting. We are actually physically not here. I am certainly not here.
I'm leaving.
Not here.
I'm leaving tomorrow.
Well, it's not. It's waited so long. Let it be right.
Manoj, I appeal for the judgment debtor. Manoj, may I just say one thing?
7 people to be heard.
Milords, I'm also suggesting your lordships may, but your lordships may also consider.
For example, 200 crores is given against 1,000 crores.
No, heavens.
400 is
Between 15.
To go on.
How will heavens fall?
Someone who's not even a party.
How will heavens fall from 15th June to first week of July?
May I make an additional suggestion? Milords, this is an overseas party who's holding a decree. He is entitled to his enforcement. He's causing great prejudice to third parties. please put him to notice that if his application is not sustained insofar as third parties are concerned, he will be put to and required to deposit and recompense us. It can't be that it's a one-way street. You get an injunction, you prolong it, 600 and odd crores come into court, and still there is no dilution. There is no prolongation.
It's 845 crores, Manoj. 845 crores, Manoj. I appear for the judgment.
This side, the issue of mediation had not come before us. Both sides said, all right, because they were reluctant, we persuaded them to go for it.
Each time they come for mediation, no proposal is coming.
That is between the debtor, my lords, and
I appear for the judgment debtor in the mediation. If Dr. Singhvi is willing to waive his privilege before I can show that we
Yeah, all right in saying vacation, I'm not.
almost at the finishing line. And this is precisely what happened because they are armed with an interim order, they scuttled the entire mediation.
1st July or 2nd July or on 6th July, 7th July.
I would have otherwise said yes.
Yes.
I would have said yes.
Any day.
Well, I am away for a wedding in that week. Very next week.
It's been on since October and they haven't filed the appeal.
Well, it's that week I'm away abroad for a wedding.
Put it.
3 weeks. The following week, please, sir, he's asking a date. Please put in the following.
2nd week of July.
2nd week. Before your lordship opens. That particular week I'm not here.
Opening week, we will take it.
Yes.
The opening week will take up it immediately.
Yes.
Subject to that part and matter which is over.
Subject to? Yes.
One part and matter.
Yes.
Very well.
Once that finish, we will immediately start on day to day.
Very well.
My lords, my intervention would be allowed because after all the order is against me.
Yes.
My IA 159692.
All I pray to, so and so in IA is allowed. The applicant is permitted to assist the court as an intervener to counter affidavit.
My lord has passed an order against me by name.
No, but that order we are not vacating.
No. I'm saying therefore I should be.
We are allowing you.
That's all.
We are allowing you.
Well, his application wants documents to be taken in a sealed cover, etc. If it's a application, we'll respond to the application. But I don't think this sealed cover and all should.
Intervener we can always allow. Because we are passing an order.
No problem at all. The order is against him. He has to be heard. There's no objection on that. I've said so.
Item 28 and.
Grateful.
My lords, grateful.
Item 28. Item 28, Mr. Vikas Kumar Jha, advocate. Okay, not here. Even again, before we get up at 4 o'clock, reminder. No. From list on 27 July, we don't want to. Item 30.
Lords, in item 30. May I just hand in a 2-page note? Some interlocutory arrangement because, of course, we'll have to await your lordship's judgment on the constitution bench. But I have got some modest requests. I want to go and pray. So just please have a look at this note. I will just take you straight away first to para 4 and then I'll go back to para 1 onwards. Para 4. This is all without prejudice. The petitioner seeks the following interim arrangements from this honorable court without prejudice to her rights and contentions. The petitioner be permitted to offer prayers at the Nagpur Agyari. Note, there is only one Agyari. Sorry, your lordship has that. I'm on the second page, para 4A. request for interim prayers. The petitioner be permitted to offer prayers at the Nagpur Agyari. Note, there is only one Agyari in Nagpur and the nearest Agyari is Indore, which is at least 400 kilometers away. B, the petitioner be permitted to participate in the funeral prayers, Muktat prayers, with respect to her late grandmother who passed away on 6th of September 2024. C, the petitioner be permitted to attend and participate in funeral prayers of any deceased Zoroastrians. And D, the petitioner be permitted to attend the Agyari for the purposes of ceremonies and events held in the Agyari with respect to family members, relatives, and friends. Each of the requests in terms of the interim arrangements is consistent with what similarly placed Parsi Zoroastrian women enjoy in Mumbai, Delhi, Kolkata, and we've given you the page references of their rules, etc. Now just go back, Millers, if I may, just to serial number 1, paragraph 1. The relevant averments in the writ petition are set out below. The petitioner herein is a female of Parsi Zoroastrian descent. Her marriage was solemnized with a Hindu Sri so-and-so on 27th November 2009 under the Special Marriage Act. They were blessed with 2 children, a son and a daughter. That the petitioner was born to both Parsi Zoroastrian parents, Mr. Firoz Rustam Shapurji, the father, and Mrs. Nilofar Firoz Shapurji, the mother. The petitioner was brought up in a Parsi household following Parsi Zoroastrian religious practices and customs. The petitioner has always been a Parsi Zoroastrian woman and has always practiced her religion and never renounced it. The petitioner has tried to convince the respondent number 1 to remove the gender discrimination. However, the respondent number 1 has always given some or the other excuse to delay the same. Then we've given you the statement of objects and reasons of the Special Marriage Act, which is exactly to allow interfaith marriages. Then please see para 3. The writ petition assails Rule 5.2 of the Constitution of the Nagpur Parsi Panchayat. Rule 5.3 is also extracted to demonstrate the differential treatment meted out to Parsi women as compared to Parsi men. Now please see clause 2. Any 5.2. Any Parsi Irani Zoroastrian woman who marries a non-Parsi man and bears children from such an alliance, then such a woman and her children will not be accepted as Parsi Irani Zarathustris. Any Parsi Irani Zoroastrian man who marries a non-Parsi woman and has children from such alliance, then such woman and her children will not be entitled to any of the privileges or benefits of the Parsi Panchayat funds and properties.
Mr. Dewan, this issue, particularly the issue of Parsi woman vis-a-vis Parsi man, that has been argued at length.
Yes, in the larger, I want an interim arrangement.
No, today passing any order which will directly or indirectly reflect an opinion it's not advisable. We will also appreciate this. We two of us, brother.
She's getting tagged with this money.
Can I wait?
This has to be done consensually, my lord.
Mr. Singh, in other cases, on consent as an exception, similar orders.
Well, just to clarify that.
Please take that instruction.
Well, I can take that instruction. My lords can keep it, but as of now I've been informed.
If you can take instruction, Mr. Balbir Singh.
Yes.
For the limited period till the judgment comes, then whatever law will be laid down, that in any case everybody will follow.
Let's can keep it on Friday. I'll take instruction.
Yes, please. And on consent without
prejudice to your right.
No, sir, I'll first check what the position is. I understand is
other panchayats have permitted. Yes. Supply those orders.
That's what I say. If they can supply where the other consent, because my understanding is that the temple there is no restraint, just to make it clear.
But then allow me to pray. That's a big step forward. Please record a statement that I can come and offer prayers.
On Friday.
Please get hold of those orders on consent to the extent the other panchayats are permitted. Attend funeral prayers of the father or relations, etc. To that extent,
I'll request Mr. Dewan to provide me. I'll be happy.
That's been done. I've provided those rules in the IA, etc.
No,
they're being allowed.
Where the consent orders are there.
This board.
In that Gulrukh, there is a order, etc.
Yes,
We'll
yes,
all
yes.
right.
Just apply that.
Okay, very well.
In those lines, we can pass the order without,
Yes,
giving the order is sort of a prima facie view of the.
Yes, very well.
Let me look into those.
Friday.
Grateful.
Great.
Item 43.1.
Lordship, item 43, Lordship, is a contempt petition. And item 43, the lead one, is a contempt petition arising out of those demolition matters, where my Gurdwara was demolished and the Guru Granth Sahib was taken away.
That how we directly entertain contempt, because you have to first establish your claim before some forum.
Lordships, at that time, there was an order operating of this honorable court, which has finally resulted in a final judgment, which is also to my benefit, that no demolitions done throughout the country. During that period, in 1st October is that order of this honorable court, and in October, they have without notice come and demolished my
Mr. Sikal, we will
Gurdwara.
take up your matter around 2:30.
I was making a request, Mullah, then I asked the attorney also that let's sit together and resolve this, Mullah. And I'm making that request, Mullah, and my learned friend hopefully will agree. Hopefully.
Yep, if you amicably resolve, we will be the most happiest person.
You know, some callers come today. Well, I wouldn't like to oppose the call. So if Lordships can keep the matter hearing in July, immediately after the vacation.
Well, we'll try and resolve. Mullah, this is best resolved, but there are so many very.
You can, whatever you think.
Relationship.
Exactly, Mullah. Because there are so many other projects. We don't want to spoil our relationship at the same time. This is not something that, and also, Mullah.
And it's not an insurmountable difficulty.
That's correct. That's correct. We're still working the field. There are other fields we are working.
Here in the other connected arbitration matter, I know what went wrong where. I don't want to get into all that. A good request, Honorable. I think we should try to look into very seriously.
So what do you want now?
We'll have it after July, Mullah.
Immediately in the first, so that we keep.
Whenever your Lordships have the
Can
time.
keep it for directions in the first week of July.
First week of July.
For directions, Mullah. Yeah, for directions.
Arguments heard in part. Arguments heard in part. Post the matter, because we don't want our labor to start again. That's
Yes.
Appreciate Mr. Sikal.
Yes. Maybe it's better end of July if you don't mind, because in beginning it's difficult and June is a very hot time.
In that case, it will go second week of
Second week of-
opening. That means on 21st.
Very well.
On 21st.
21st of July.
Yes.
Week will be opening, will be entirely miscellaneous.
Right.
And you're also having some other constitution bench matters, I'm told.
No, then we will adjust for this.
Very well.
It will go on 21st.
For directions, naturally. Deeply obliged, Mullah. Really obliged.
And item 43.1.
Yes, Madam. I appear for the respondents.
Yes. So. Okay. Yes, ma'am, suggest.
Point one, please.
Yes.
quickly.
I appear,
Yes.
my lord, for the respondents.
Yes.
I appear for the respondent.
Lordships,
What
this
is the
is-
issue?
Yes, the issue is that since 1950s, I have a Gurdwara there in Kolaba, and that was summarily demolished on 15th October 2024, while this honorable court's interim
Lord, we
order
have, and there is some urgency. Let me just hear me for 2 minutes after my friend completes.
admitted and apologized, and they've admitted that they demolished it without giving any notice. Now, my first prayer is that status quo ante should be restored. Your lordships in DDA, skipper, and host of judgments have held that contemner cannot be allowed to enjoy the fruits of the contempt, and my Gurdwara should be restored. My Guru Granth Sahib should be returned to me. That should be reconstructed. That's my respectful submission. Now, a 4-story building has come up over there, which they are claiming.
Where is this, which place it was there?
In
In
Kolaba.
Kolaba, Your Lordship. Since 1950s, I have documents. And admittedly, without giving any notice whatsoever, they have demolished it.
Now may I submit, my lord?
And now today they have filed an IA before this honorable court saying they want to dig up that area specifically where the Gurdwara was because they want to lay some sanitation lines for this newly constructed building. In fact, when they were constructing the building also, I issued notice to them, which I filed by way of additional documents, that you are in further contempt of contempt now.
Pull those out.
But they did not desist, and now they want to dig up that very area where the Gurdwara was in order to construct a sanitation line for this building. That is what the IA that is listed today.
Is something is a very essential public service.
Yes, but lordships, my Gurdwara has been demolished without giving me any.
No, that part we will see. That they are asking only to construct now in the open area or sewage.
In the alternative, then may I suggest, let them pay me compensation as per
there's
the
no question,
2013 Act. Now that this building has come up, that's what I suggested to my client because, and my Guru Granth Sahib should be returned to me. (1950s) commencement certificate I have.
One, the order of which the contempt is complained about, that specifically says that any encroachment on a public area will not be saved by the order. These are the documents where MCGM is the owner of the land, not a single document of title. Number two, I will show the frivolity and the gross abuse. They do not disclose that for the same relief, they have already gone to the Bombay High Court in a writ petition which is pending. They don't disclose it in their contempt. That is still pending, my lord. All these prayers of return of Guru Granth Sahib and all of that, they are pending there. Then, my lord, now this land, what has come up here is a residential quarter for the sanitation workers of the BMC. They are all ready. The building is ready. My lord, may see the photographs. The sanitation workers are homeless today. My lord, we have constructed.
No, you need area for drainage.
Exactly, my lord. Because for them to shift in, the drainage and sewerage process must be conducted and finished. These tenements are for sanitation workers. Millard, a rank encroacher comes to the court and says that
I have
a
documents.
single document of title
The land belongs to whom?
to the MCGM.
Lordship, I am a
Let me see this.
1950s, I have commencement.
No, that's right. But the land is owned by, as per record, by whom?
MCGM.
Lordship, it is owned by them.
In any case, you have entitled to claim that it's a
Permission.
One can maybe that successfully argue
Yes.
that there is a religious place, a structure at the site and it's from 1950, but that issue is pending before the High Court, right?
Lordship, I have filed a writ pursuant to the demolition, which I have disclosed.
That
I
is the
filed.
correct approach also that you have filed before you need a declaration from a court. Contempt will arise later on. That is the right approach.
Lordship,
But
contempt,
today-
as I respectfully stated, your lordships had prohibited any demolitions during that period.
Yeah, but in the open area, for these poor sanitary workers,
Lordship, I am also.
Millard, all demolitions may I submit.
Man is not
Millard, may see page.
afford a lawyer
Millard, may
also,
just
to be
see
honest.
for a moment, take up page 29.
969/2025, hard learned counsel for the party. The prayer in the application is allowed. The respondent applicants are permitted to clear the encroachment for the purpose of carrying out drainage from a sewerage water supply and storm water drainage work for the Ashray Yojana.
Lordship,
Ashray Yojana.
For
because
completion of
tenements are under that.
Ashray Yojana redevelopment project. However, this will be without prejudice to all types of claims, including the title or compensation claim raised by the occupants and the occupants who claim that the site is being used as a Gurdwara Sahib. We have not expressed any opinion with respect to the claims and counterclaims of the party for the reason that the matter is sub judice before the Bombay High Court.
Lordship may direct them to restore status quo. They have to only dig under the floor.
Millard, the High Court
Lordship
will
may
deal
not
with that,
direct
Millard.
people of
Otherwise, we are facing a lot of
Because
problem on
after
the ground,
demolition-
Millard.
Parties are say, are permitted to approach the High Court for an early disposal of the pending writ petition. The High Court
I have status quo since 24.
to provide expeditious hearing in the matter.
I'm grateful.
Lordship, may direct them to maintain status quo after
No,
completing
Milord, we
that
have to
card.
finish
Because
the
of
work.
my
We will need to a lot of
granted
It
status
cannot be because
since 2024.
these poor sanitary workers need drainage and sewerage.
waiting for their houses.
Lordship, but my Gurudwara since 1950 and my residential place is there. Now my
But they will not. They will only, they are using only the open. फिर कहाँ से निकाल के?
Lordship
सारे रखो यहाँ पे.
may continue status quo and allow me to approach Bombay High Court for interim relief. Because
Yeah,
I
we
am having interim relief.
Bombay High Court we have said.
24.
We have said so.
This is my interim relief before Bombay High Court during that period.
Item 44.
Grateful.
Because I am in item 43.2. It is a connected matter for demolition that has taken place. Because the notice was pasted in my app on 2nd of.
Go and challenge that notice. How?
Because I'll brief about this. There was a land acquisition by the KIDP, which was pending in the High Court. While the writ petition was pending, there was a notice which was pasted in my absence. I brought that notice in the notice of the High Court. There was the matter was still under adjudication. Then, within 7 days, the demolition was supposed to be taken place, which is the contemptuous notice as per the judgment. Now, my lords, while the High Court matter was pending, I approached the District Court for the temporary injunction, my lords, that by that time the District Court issued notice, my lords, the demolition has already taken place.
It's all right.
Now, my lords,
Land is under acquisition. Where is the question of contempt?
my lords, because the
No case to initiate contempt.
my lords, may I highlight? My lords, may I highlight?
The acquisition is under challenge before the High Court, and where no interim relief is taken.
Because the High Court proceedings are already over. They have passed the order in my favor now.
Well, then get it back after the
Because the High Court writ petition was pertaining to the land acquisition, which.
That's right. So in the land acquisition, if they have done anything wrong, claim damage is there.
Because there is may I refer to one notification?
Thank you very much. Thank you. These are not contempt.
I'm in 43.3, my lords.
Or the petition.
I am only requesting that to break with the main matter, my lords. It will be tagged, my lords.
Lords, I appear in 43.3.
Your Lordship, please. No, in item
What's
44.
43.3, my lords? I am purchaser, my lords, of 2 plots, my lords, by way of registered sale deeds. Lords,
Sir, all of you are directly filing contempt. Where is the adjudication of your claim that first you are owner, 2 that it is lawfully constructed, and 3rd that it has been wrongly demolished? Unless these 3 finding, how contempt?
Lords, there is no notice to be admittedly, my lords, there is no notice given to me at all.
Then,
my lords, the land, my lords, only 2 documents may I show.
Down to the court, High Court or Civil Court, get a declaration, get a finding of fact that you are the owner of the property, no notice was issued to you, and demolition has been made.
Lords, there is no dispute as to the fact that, Lords, I am the owner because I have annexed registered sale deeds. Lords, August 2008, Lords, the SDM converts this land.
Supreme Court to be decided that your title and
Lords, this is, Lords, in my respectful submission, this is directly, Lords, in breach of the judgment passed by this honorable court. Lords, kindly look at one document. Lords, NGT petition is pending. Lords, where YEDA is a party. Lords, they make a wrong statement that no case is pending. Lords, in the letter which is written by YEDA, Lords, to SDM.
Bring them piecemeal, I can't understand. Thank you very much. Thank
Lords,
you.
may I, Lords, in that case, may I?
44, what are the?
Your Lordship.
My Lords may grant me permission, my Lords, to approach the Honorable High Court in
Yes, why not?
43.3
Right.
record.
No case to initiate contempt. For determination of their rights.
Grateful, Lords.
Just a bit of factual information in this matter. In item 44, prior to your Lordship judgment in November 2025, about 11 vacancies, the selection process on, but it was held up after the judgment. Now we only need to the SCSC committee to interview those candidates, and the selection can be complete as far as they are concerned, but without being affected by the judgment. So in which case, I would probably move an application seeking exemption from the judgment in order to complete this process of completion of 11 posts can be filled up. Then another 14 posts will be probably vacant by the end of December. Before that, we'll have all that exercise of making a new law and all that. If you'll also permit me to put a note on Friday, so we can take it forward. How to take it forward.
Well, Justice.
Either the court permits us to go along with the completion of the selection process in respect of those people whose selections almost are advanced, except the interview by the AC. If that can be done, we can fill up those posts now. So subject to Lordship's direction, or I'll put in a note on Friday.
The Justice Anil Kumar is demitting office on 30th 5/26 this May.
No, they are saying that now the press selection process is almost over.
But for the post which has already been vacant, my lord, for not
There's only
the
one.
post which is going to be vacant or which are expired, or those terms are
So
expired.
it should not
That is
look like
December.
as if the individual members are getting petitions filed. It should not look like.
No, not that, my lord. If your lordship may see page for
How many
next.
selections have been made, Mr. Attorney, and how many appointments are likely to be made, suppose?
11 appointments can be made if you Lordship permit me to go along the earlier regime. So there are other 12 likely to occur around 12th of December 2026. By the time we have crossed many milestones, the new law will come. So why should we now get into that question? As of now,
Can you give us a formal affidavit kind of or some?
I will give
Giving complete status of it.
Your Lordship, please.
When should you take up?
On Friday, Your Lordship can take it up on Friday or immediately after reopening.
MeitY has to be filed to modify the direction in Madras Bar Association.
Either we make these appointments or we don't make any appointments at all.
Meanwhile, Mr. Attorney, maybe you can first examine.
Your Lordship.
Mr. Attorney, you said that by August, there will be a new regime and the appointment process. That is why we extended the
Till September.
terms of all the
Till September.
tribunal
I know.
till August or
Correct,
September.
correct.
Because what proposal you are giving now
If-
will require us to modify the
Absolutely.
original direction, which can only be done by way of an MA.
I know.
We
So
can't
if,
do
but
it.
then since the urgency is project, I thought if that can be an interim arrangement, there'll be no difficulty about that.
Sir.
But see, you don't want to create
Maybe
further
appropriate-
That
further
was more
confusion.
complication.
Correct. You Lord kindly take it up
Then
in
we
July.
can- In the opening of week.
Please.
And meanwhile, you file that.
Very well.
July.
My lord, till then, your lordship has directions that it will be applicable to all tribunals, those who are debating that will be.
That order has
No
already
further
been
orders are
passed.
required now.
The Consul, Mr. Attorney has already assured us.
Please.
No one will be removed till August or September.
Till September 9.
Yes,
That's
September.
the order passed, Your Lordship.
Because says that by July, August, a new regime will be.
Only difficulty which I'm pressing is that because this Armed Force Tribunal is under the Ministry of Defense and the others
The
are
Attorney
under
General
the.
represents the Union of India. Ministry of
Please.
Defense is not outside the
Please.
Union of India.
Please, my lord.
Item 20, item
Very
20.
Please.
Item 31.
Because as per the officer report, it seems that the service is not complete on the sole respondent.
Use the mic, person.
My lords, item 20, the office report indicates that service is not complete, my lords.
That's right. Madam Prerna, then take the necessary steps for
Very well, my
court services incomplete with the notice sent has been received back to the postal marks, door locked and unclaimed. Let correct address of the respondent be. If they agree, you can have to hand out and let correct address of the respondent be furnished within 1 week, where from fresh notice we issued returnable on so and so date.
very well,
Great.
my obliged.
Item 21.
Please, Vinod.
Application. And the notice. If they agree, we can appoint advocate.
Do you agree?
We filed a counter affidavit. We were told that the petitioners might take time for some rejoinder. We clarified with them on Saturday.
Milords, Mr. Ehtisham Huda is appearing through VC, Milords, if he may be unmuted. Milords, for the petitioners, Milords.
In item 21, you are appearing for whom, madam?
My lords, I am appearing for the petitioner along with Mr. Syed Ehtisham Huda, my lords. He is online, my lords. If he can be unmuted, my lords.
Do we want to file any rejoinder?
My lords, we want to file a rejoinder. We wish to take time for rejoinder, my lords.
Item 22.
So grateful, my lords.
Grateful, my lords.
My lords, for the petitioner, my lords. Lord, the respondent has been served through substituted mode, my lords, through email. Lord, they have been served through email. My lords, may I mention, my lord, the report from the ministry has been awaited, my lords, and it has not been.
Item 23.
Please, my lord, in item 23, my lord, this is a section 11 petition, two petitions, my lord. The arbitration clause is at page 40, my lord. My lord, in item 23, the arbitration agreement is at page 40, my lord. They filed their counter, my lord. There is some dispute as to the validity of this clause, my lord, which to my mind is not invalid, my lord. May I have page 40 clause.
Please, my lord, I appear for the respondent. My lord,
Yes,
we've actually also, we've written to the councils also regarding if we could have a mediation with regard to this matter. But there are some issues when it comes to the clause where we believe that it's not, it will become inoperable because there is a choice of law. If
we can refer you to mediation.
My lord, may appoint the arbitrator,
Yes,
my lord, initiate proceedings, my lord.
No, if the arbitrator is appointed, then where is the question of mediation?
My lord, the arbitrator
Please,
can perhaps mediate if at all, my lord, if arbitration can be initiated, my lord, we'll go to.
So,
madam, my request.
we can only request the arbitrator to first, but then once he mediate, then he will disqualify himself.
Madam, my request would be to let it happen before the mediation center of the court itself.
Would my lord do this, my lord? My lord may refer me to mediation, and if mediation fails, then arbitration may proceed, my lord.
All right, then we appoint an arbitrator, then matter ending.
My lord, my then request on this is only with respect to the clause. May just look at the clause itself. There is actually going to be a lot of functional issue when it comes to this clause because it talks about two governing laws. There might be conflicts as to limitation, validity of contract, all of that. And my lord, there is also an issue with the forum selection because it says after all of that, it gives a notwithstanding clause that the courts of Bombay will have jurisdiction. My lord, may just see page 50.
These arguments are there before the arbitrator that you will raise there. How much?
Madam, in my
About
humble
5
submission.
crore in both matters.
5 crore in Bombay.
In Bombay, my lord.
So that we'll find out some former judgment.
My lord, I reply.
Item 31.
My lord, senior counsel.
31, my lords, I am being led by Indian Solicitor General.
What happened? You were supposed to
Lords,
settle it.
working out the modalities internally, my lords, but
Do it, right?
My lord,
Justice Kannan, a senior, is appearing through VC.
May it please, my lords. In fact, this has been the burden of the song for the last 3 hearings. What would seem to be a fully adjudicated claim, and where my lords have observed that a portion of the amount of at least for 8,636 square meters amount must be paid. That was passed on 16/3/26. We are full 3 months away, and we have the same kind of observations. In fact, at the previous
we
hearing,
make our submissions, my lord. We kindly have the matter tomorrow or day after, my lords.
no, he must be making the payment, my lord. There must be some bona fides in what he's saying. Because my lord sees now, this is in a contempt petition. He's literally aggravating the contempt by giving an offering in the court, gives an assurance through a top officer saying that he will make the payment and makes no payment. And it would seem unfair. It happened the previous time as well on 34, where
1 week more time you are granting, Mr. Kannan. 1 week more time is granted to the
let it be for making the payment, my lord. It should be like that. Where is he breaching it again? Friday, my lord.
Compliance report. Post the matter of so and so.
Please allow me to file, my lord.
Go here.
27 July. No?
My lord, please allow me to file the written submission in Sabrimala. My lord.
My lord, permit me to make a request. My lord, in the morning I have make a mention. My lord, I presume that it is going to be listed today. My lord, all objections are clear. I am filing in the exemption clause. My lord, I am not seeking any ban on any election. It is at the maximum one ward of Nagar Panchayat, my lord. It is, my lord, against not the petition. I am, my lord, the latest three judgments of this court.
We'll examine your.
My lord, I have filed the, my lord.
You will examine.
Kindly, my lord. Humble request, my lord.
Manoj, may I mention? Manoj, recently the Scora election had taken place. Manoj, among the ladies reservation candidate, Manoj, I have secured 507 votes. So, Manoj, on the top 4, they are ladies. But, Manoj, as per my lord's direction, Manoj, 2 posts are reserved for the women. Manoj, I had made one representation today. Manoj, may kindly direct the election committee to consider.
No, we will not, we'll examine it.
My lord,